Good morning once again.
Good morning.
Good morning, sir.
Good morning, sir. So in the second session, we are discussing on law of war and the role of United Nations. In the last session, we had a discussion on bioterrorism. I'll give you just 5 minutes to have some questions. Any question in connection to the last session, please ask me. ಪ್ರಶ್ನೆಗಳು ಇದ್ರೆ ಕೇಳಬಹುದು ಲಾಸ್ಟ್ ಸೆಷನ್ ಗೆ ಸಂಬಂಧಪಟ್ಟಂತೆ 5 ನಿಮಿಷ ಮಾತ್ರ ಅದಾದ್ಮೇಲೆ ನಾನು ಅಲ್ಲಿ ಶೇರ್ ಫ್ಯೂ ಥಾಟ್ಸ್ ಆನ್ law of war and role of United Nations organization. So, ಪ್ರಶ್ನೆಗಳು ಇಲ್ಲ ಅಂದ್ರೆ shall I proceed to the topic?
Yes, sir.
Thank you. Yeah.
Yes, sir. Okay, sir.
Yeah. Dear participants and my esteemed colleagues, in this session we are discussing on the concept of war. Before I'm going to deal with the concept of war, it requires to understand some of the gigantic, complicated and wider issues of this word as such. Of course, much has been discussed on the concept of war. It could be internal armed conflict and international armed conflict. We know that internal armed conflicts are 100 times dangerous than international armed conflicts. When we look from the perspective of internal armed conflict, this has happened in many countries, which includes our own neighboring country, Sri Lanka. In 2009, by killing Prabhakaran, the internal armed conflict was put an end. When you are understanding the war, the concept of war or war itself, there are many miserable conditions. How would you overcome? And moreover, as you have already been known, during war situation, women and children are going to be targeted. So here, understanding the humanitarian law is one, and focusing on some of the international covenants, agreements between states themselves, are the ways in which one should be looked upon. This is what the International Rescue Committee has assessed the countries at the greatest risk of a humanitarian crisis in 2020 as such. The conflicts and instabilities in Central African Republic continue to develop widespread many issues. At 2.6 million people, more than half of the country's population requires humanitarian assistance. Over a quarter of all Central Africans have been forced to leave their homes more than 6 lakh people have been internally displaced, while a further 6 lakh have fled to neighboring countries. Around 35% of the population are experiencing critical levels of food insecurity, especially in Central African Republic as such. This is what the International Rescue Committee has already been looked into and found some solutions to overcome some of the problems, especially in these areas are concerned. Look at in Somalia, which has been persistent instability and conflict since 1991. More than 5 million Somalis, I mean to say, over 40% of the population need some form of humanitarian assistance. Over 1 million face crisis levels of food insecurity even today. Conflict has actually driven 740,000 Somalis to nearby countries and to a further 2.6 million people are actually displaced within the country. Flooding at the end of 2019 could push these numbers to record levels as such. So apart from these two countries, look at the civil conflicts in South Sudan has actually killed almost all 4 lakh people since 2013. 7.5 million people need humanitarian assistance. And in fact, the crisis has created 2.2 million refugees and displaced 105 million inside the countries as such. If you go on searching some data available in net, you will be astonishing to share few thoughts on these issues and challenges like refugee crisis and internally displaced persons are concerned. When it comes to knowledge of India's position, we have more than 7 lakh internally displaced persons. Except Article 21 of Indian Constitution, no law is there to protect them. In 2005, in fact, we had a bill which had to be passed by Parliament. Due to political issues and challenges, this bill was unsuccessful. These are the crises we have when it comes to the knowledge of internally displaced persons are concerned. Thanks to United Nations Organization for appointing Francis Deng of Sudan, who was actually pursued a very good research on internally displaced persons all over the world. In 1998, in fact, he came out with a guiding principle on protection of internally displaced persons in 1998. Except these few specific, international legislations, we are not finding sound, laws to overcome some of the issues and challenges of internally displaced persons are concerned. So in this context, understanding the war is one. It is because of these armed conflicts, people are going to be vulnerable, retracted, and marginalized. You can make a list of the people who have been actually affected by war as such. They could be refugees. Look at Afghanistan crisis in these days. In Afghanistan, many people, civilians, they've flown over to many countries and they have become refugees nowadays. And moreover, if rather I would say, we have so many international agencies who have set up to overcome problems of refugees and internally displaced persons as well. It requires a lot of drill when you are actually relying on refugee crisis. Look at Article 3 of Refugee Status Convention 1951, wherein it has defined who is a refugee. Refugee is a person who has been fled his home country due to well-founded fear and persecution. This definition is very broad. 1951, we were able to define who is a refugee. Now, that definition has to be changed, and we need to have a very good definition, that is natural definition on refugee. Who is a refugee nowadays? How will you understand the reasons for refugee crisis? That's very, very important from the point of view of understanding refugees and the internally displaced persons are concerned. There is a dichotomy between internally displaced persons and refugees are concerned. What does it mean? A refugee is a person who has been fled his home country and he is supposed to cross his international borders. Once he has crossed an international border, he will be called as if a refugee outside the country. But it's not so in the case of a internal displaced person is concerned. A person who has been displaced shall not cross an international border. He is supposed to be within the limits of municipal law or the national law as such. So these are the two dichotomies we have when you are actually relying on a refugee and internal displaced person are concerned. These are the two things that shall be looked upon when you are actually understanding humanitarian assistance, which could be rendered by many agencies are concerned. So that's why United Nations organization has set up as many as specialized agencies to understand peace on this Earth planet as such. That's why United Nations High Commissioner for Refugee was set up on the basis of 1951 Refugee Status Convention as such. Since then, we have been talking more on the protection of refugees all along. Apart from this, more than half of the population of Syria has been displaced by conflict since 2001. The war has actually increased 5.7 million refugees, 11 million Syrians. I mean to say 65% of the population are in need of humanitarian assistance even today. Look at, as just over 5 million people, the Democratic Republic of Congo has largest international displaced population in Africa. 15.9 million people require humanitarian assistance even today, and 15.6 suffer from crisis levels of food insecurity. And you know very well, Congo is the second largest Ebola outbreak in history as such. So these are the crises which are highly expressive at the international level as well. Look at even in Yemen also. So apart from these states, we have 5 of the worst countries of human trafficking. This is also quite challenging issues when it comes to the knowledge of the need for the application of public international law as such. Then what is the role to be played by international law? How, in what manner international law should be effectively transformed into the municipal law as such? When you are actually understanding the national and international law, there are so many theoretical applications have come through. You have monism, dualism, specific adoption theory, transformation theory, delegation theory, incorporation theory, harmonious construction theory, pluralistic theory. So many theories have set up to understand the relationship between municipal law and international law as such. So why I'm sharing, when you are actually transforming such kind of international law into the municipal law, there shall be something. There shall be something in the sense that, it depends on the constitutional checks and balances. Look at Article 253 and 51 of the Constitution of India, wherein it has outspoken on the constitutional validity of public international law. Kindly refer Article 253, wherein it is stated that notwithstanding anything contained in the Constitution of India, that the Parliament has got highest power to implement international law into the municipal law as such. Simply, you cannot follow them unless and until there shall be specific adoption theory. What is specific adoption theory? No matter, however it could be, especially in India, there is a common misconception prevailed in Indian judicial system to the effect that international covenants are not supposed to be enforceable unless and until it should be, based on some specific legislations or the parliamentarian approval as such. Unless and until you should have had parliamentary approval or specific adoption, it would be virtually impossible to transform or incorporate such kind of international law into the municipal law. So this is what Article 253 of the Constitution of India has already been outspoken, and you have already been known. Prof, you may have referred it while you were teaching Constitution to your students are concerned. So this is what somehow to be looked upon when you are actually understanding the relationship between municipal law and the international law as such. And there are some criticisms leveled against to understand the municipal law and the international law as such. It is because of these reasons so many vitiated issues are circled, and we are finding some solutions even today, but it's not possible to have them on time. So that's the reason we have been actually suffering like anything at the national and international level as such. Thanks to some of the judicial officers who could share few thoughts on the basis of Bangalore Judicial Colloquium. In 1988, we had a Bangalore Judicial Colloquium. So in that Bangalore Judicial Colloquium, so as many as a statesmen of various countries, they participated in that Bangalore Judicial Colloquium with a view to transform such kind of international human rights law into the municipal law as such. It was possible to transfer such kind of international into the municipal law. Thanks to them for having gone through all these steps to overcome certain barriers between municipal law and international law. And moreover, if the international law is not impinging the municipal law, then you can apply international law into the municipal law. So there is a lot of scope to understand them in otherwise manner. And moreover, of course, there are so many challenging issues vitiated. As far as my knowledge is concerned, this used to be in this way. A person who has been actually teaching is a human being. The people who are sitting here to listening me are also human beings. That has to be looked upon. That's a humanity shall be followed. Then the rules of humanity or the dictate of public consciousness shall also be verified when you are actually running with these observations. Otherwise, it's very difficult and meaningless as and when you deal with these criticisms are concerned. You may be wondered if you are just sharing few thoughts on human trafficking all along the world as such. Especially in Russia, about 20,000 workers from North Korea are sent to Russia each year. when you are dealing with human trafficking, especially in Russia. In China, look at the demographic challenges created by countries' one-child policy have led Chinese men to find wives through sex trafficking. This is also one of the major issues and challenges. On the other hand, especially in Iran, migrants, particularly those from Afghanistan, are coerced into combat roles in Syria, and children as young as 3 years old work as street beggars under the threat of physical and sexual abuses are concerned. Apart from these states, especially in Venezuela, you know very well, the sex trafficking and child sex tourism are common, particularly among women lured from poorer regions to tourism hubs. The government did not report any investigation even today into human trafficking or any protection effort for victims are concerned. So in this context, reasons for war are many. Even for a small thing, states are quarreling each other. Even for a small thing, like, sharing of natural resources, especially in territorial sea, contiguous zone, exclusive economic zone. Even at the bottom level of the ocean, there are huge natural resources available, like polymetallic nodal, cobalt, crushed ferromanganese and all. It is because of these reasons people are quarreling each other to extract natural resources from others. So because of these reasons, war is quite common. When you have failed in peaceful settlement of disputes, obviously you are going to invite war as such. Might be based on propaganda for such war of aggression you have, countervailing measures you have, retaliations you have, reprisal you have. All these are to be called as if coercive measures to settle disputes between states themselves. If you are sick, you'll go to a doctor, isn't it? So this has to be looked upon. Doctor yaradreno nam kaile vashi adre sakagirutte. So this has to be looked. Doctor yaradreno namma kaile vashi agbe. Hagagi ಅಂತಾರಾಷ್ಟ್ರೀಯ ಮಟ್ಟದಲ್ಲಿ ಕೆಲವೊಂದು ದ್ವಂದ್ವಗಳಿದ್ದಾವೆ, ಸಂಘರ್ಷಗಳಿದ್ದಾವೆ, ಸಮಸ್ಯೆಗಳಿದ್ದಾವೆ, ಸವಾಲುಗಳಿದ್ದಾವೆ. ಅದನ್ನ ಸರಿಪಡಿಸ್ಕೋಬೇಕಾದ್ರೆ ಕೆಲವೊಂದು ಅಂಶಗಳಿದ್ದಾವೆ. ಶಾಂತಿಯುತವಾಗಿ ಬಗೆಹರಿಸ್ಕೋಬಹುದು. ಒಂದು ವೇಳೆ ಶಾಂತಿಯುತವಾಗಿ ಬಗೆಹರಿಸಲಿಲ್ಲ ಅಂತಂದ್ರೆ we have to invite war. War is not a sin. War is a last resort to decide. When we had first and second world war, we decided to resolve some disputes between the states themselves. There is a history one has to understand. Before the coming into force of a Treaty of Westphalia 1648, we had 30 years of war in Europe. Entire Europe was battlefield, and there was no scope for protection of your human rights and freedoms as well. Please understand here. The entire Europe was battlefield during 30 years of war. It was a religious war, one has to understand. We had religious war between states themselves. So we wanted to put an end to that religious war by making a peace treaty. That peace treaty had to be called as if Treaty of Westphalia 1648. Then the people started working on peace and war. None other than Hugo Grotius, father of public international law. Then Prof, Banker Shock, Oppenheim, Latter Patch, as many as professors and the people who were very much interested to have some research on public international law. Written number of the books on the public international laws. Based on these, we have been emphasizing on what is law of war, as how, in what manner law of war shall be looked upon. See, when it comes to the knowledge of a law of war is actually divided into three. We have a aerial warfare, naval warfare, and a land warfare. Aerial warfare, naval warfare, land warfare. It is depending on the war in which you are inviting. If it is land warfare, based on land warfare, there are some specific legislations and international conventions. If it is aerial warfare, there are some international covenants and national legislations when it comes to the knowledge of aerial warfare. If it is naval warfare, there are so many international agreements and national legislation to understand naval warfare as such. So this is what one has to understand the law of war. What is law of war? ಅಂದ್ರೆ ಯುದ್ಧ ಮಾಡ್ಬೇಕಾದ್ರೆ ಒಂದು ಕಾನೂನು ಇದೆಯಲ್ಲ. ಈಗ ಉದಾಹರಣೆಗೆ ಹಿಂದೆ ನಮಗೆ ಸಾಕಷ್ಟು ಇನ್ಪುಟ್ಸ್ಗಳಿದ್ದು. ಉದಾಹರಣೆಗೆ ನೀವು ಲೇವಿಯಾತನ್ನಲ್ಲಿ ಹಾಬ್ಸ್ ಹೇಳಿದ್ದಾಗಿರ್ಬೋದು, ಅಥವಾ ಲೇಬರ್ ಕೋಡ್ ಅಂತ. ಲೇಬರ್ ಕೋಡ್ ಅಮೆರಿಕನ್ ಸಿವಿಲ್ ವಾರ್ ಬಗ್ಗೆ ಹೇಳುತ್ತೆ. ಅಮೆರಿಕನ್ ಸಿವಿಲ್ ವಾರ್ ಬಗ್ಗೆ ಹೇಳುತ್ತೆ. ಆಮೇಲೆ ಮಾರ್ಟಿನ್ಸ್ ಕ್ಲಾಸ್ ಅಂತ ಪಬ್ಲಿಕ್ ಡಿಕ್ಟೇಟ್ ಆಫ್ ಪಬ್ಲಿಕ್ ಕಾನ್ಸಿಯಸ್ನೆಸ್ ಬಗ್ಗೆ ಹೇಳುತ್ತೆ. ಅದಾದ ನಂತರ ಏನಾಯ್ತು ಅಂತಂದ್ರೆ 1864 ಅಲ್ಲಿ ಜಿನೆವಾ ಕನ್ವೆನ್ಷನ್ಸ್ ಬಂತು. ಆ ಜಿನೆವಾ ಕನ್ವೆನ್ಷನ್ಸ್ ಯಾಕೆ ಬಂತು ಅಂದ್ರೆ, there was an effort made by Henry Dunant. ನಿಮಗೆ ಗೊತ್ತಿದೆ ಹೆನ್ರಿ ಡುನಾಂಟ್, ಫೌಂಡರ್ ಆಫ್ ICRC, ಇಂಟರ್ನ್ಯಾಷನಲ್ ಕಮಿಟಿ ಆಫ್ ರೆಡ್ ಕ್ರಾಸ್. ಓಕೆ, ಅವ್ರು ಏನಾಯ್ತು ಅಂದ್ರೆ, he was a small business man in Europe. When he was actually crossing Battle of Salferino, he saw many wounded and sick. He in fact took them to nearest room and started giving first aid. One fine day, he sat with his friends and started writing something on a memory of a Battle of Salferino. That book is available elsewhere. Memory of a Battle of Salferino. Kindly read it. You will have known how, in what manner international humanitarian law has been established at the international level. Thanks to him, that credit goes to, in fact, Henry Dunant, who is the founder of ICRC, that's the International Committee of Red Cross as such, who is known for humanitarian law. It was because of his efforts made at the international level in 1864, Geneva Convention on law of war came out with some concrete solutions to understand the civilians. I mean to say, the innocent people shall not be killed, and the people who are involved with war situation should also be treated humanly. They're all human beings who are fighting for their victory. So when they are fighting for their victory, obviously humanity shall be looked upon to be understood. This is what the law of war is actually teaching you in otherwise manner as such. Yeah, purpose of laws. So why you need to understand the war as such? See, war should be limited to achieving the political goals that started the war, that is territorial control you have, and should not include unnecessary destruction. And you have no moral right to bombard on like Mysore Palace or KRS reservoir or dam. You cannot bombard on cultural property as such. It is totally prohibited as far as the convention on the protection of cultural property during armed conflict in 1994 as such. And war should be brought to an end as quickly as possible. You shall not be prolonging like anything. That has to be put an end by making peace treaty between states themselves. As I said, Treaty of Westphalia or Treaty of Westphalia, Treaty of Versailles, for example, Kellang beyond fact might be. You have a League of Nations, you have a United Nations Organization Charter 1945. These are the treaties have set up with a view to maintain or restore international peace and security at the international level. And of course, League of Nations was actually utterly failed due to some reasons, you know very well. It did not strictly prohibit the war, and it had some functional deficiencies. It had some functional deficiencies, and it was because of these functional deficiencies, League of Nations was actually utterly failed. It was because of its failure we invited, Second World War as such. This used to be called as a child of war as such, child of war. These are the major issues and challenges we have when it comes to the knowledge of League of Nations, which was set up to restore or maintain international peace and security as such. And moreover, people and property that do not contribute to the war effort should be protected against unnecessary destruction and hardship as such. When the war is started, obviously, some portions of the land can be captured by enemies. Once they have been actually captured, the people who are living over there should be treated humanly. You have no moral right to kill them. You can kill combatants. I mean to say combatants in the sense that the people who are involved during war situation should be called as combatants. You can kill them, no matter. However, while you are killing them based on your military necessity, you should know humanity. This is very, very important. You have to balance the interest between military necessity and the humanity. That's why the rule of proportionality established. What is rule of proportionality? What does it mean? Rule of proportionality in the sense that you have to understand rule of humanity and the military necessity as such. These should be balanced while you are actually understanding the war as such. It could be internal armed conflict or international armed conflict as such. So that's why you have to understand. There are some principles of war. Please understand them. We have military necessity, distinction, we have proportionality, humanity. Like, honor is a principle that demands a certain amount of fairness and mutual respect between adversaries. Adversaries in the sense that you have to observe humanity. The rules of humanity shall be looked upon when you are actually waging war with other nations are concerned. These are the basic principles of law of war we have. Kindly have a look on military necessity. This has happened especially in Eichmann case when Eichmann killed civilians. Of course, no matter, he was actually working with Hitler. Based on the order issued by Hitler, he killed civilians and he escaped from the clutches of law. And he was living in some countries. He was caught due to all these explanations and produced before Nuremberg trial and prosecuted like anything. And he was arguing like in otherwise manner. It was because of the order issued by a commander, I killed civilians, he said. Then the judges of Nuremberg trial, they rejected his contention and gave punishment. This has happened to Eichmann as such. That's there. You can have a look on even in internet as such. You can understand where exactly Eichmann was targeted based on Nuremberg trial as such. This has happened. See, when you are actually running with military necessity, humanity shall be observed. That's very, very important. And moreover, you have to have distinction. Our combatants, howdo, ಅಥವಾ non combatants, ಇವೆಲ್ಲ distinction ಮಾಡಬೇಕಾಗ್ತದೆ. when you are actually running with a war as such. That proportionality shall be looked, as I said. You have to balance the interest between military necessity and the humanity. So that's why the rule of proportionality was exposed at the higher level as such. And moreover, there shall be a declaration of war. This is what even in Bhagavad Gita, declaration of war is actually emphasized. That has to be looked upon. So apart from these earlier history, we have so many specific international covenants, like 1858 Paris Declaration respecting maritime law. Then you have 1864 Geneva Convention for amelioration of the conditions of sick and wounded in armed forces in the field of in the sense that it could be battle or war situation as such. 1868 St. Petersburg Declaration renouncing the use of explosive projectiles under 400 grams weight. 1874 project of an international declaration concerning laws and customs of war. We have 1880 manual of law, the laws and customs of war at Oxford. You have 1899 Hague Conventions consisted of three main sections, three additional declarations. You have 1907 Hague Conventions had 13 sections, of which 12 were actually ratified and entered into force, and 2 declarations. And 1909 London Declaration you have 1922 Washington Naval Treaty, known as the 5-power treaty between states themselves. Apart from this, you have a Kellogg-Briand Pact, which is known as the Pact of Paris. Pact of Paris 1928. We have obviously Geneva Convention related to the treatment of prisoners of war. The prisoners of war should be treated humanly. That has to be looked upon. Especially in the 1929 Geneva Convention on the amelioration of the condition of the wounded and sick came out with humanitarian perceptions to understand all these people all along. 1930 Treaty for Limitation and Reduction of Naval Amendment you have. Then Icrc Pact you have, London Naval Treaty you have. So all these laws have come through. Apart from these, you have International Military Tribunal at Nuremberg, 1946, in which your Heichmann was prosecuted before this military tribunal, and who were responsible for crimes against humanity, war crimes, genocide, and peace were actually targeted in this international military tribunal. In 1947, Nuremberg Trade Principles formulated under General Assembly resolution. In 1948, you know very well, United Nations Convention on Prevention and Punishment of Crime of Genocide came out with some concrete solutions. In 1949, Geneva Convention for amelioration of the condition of wounded and sick and armed force in the field, especially battlefield or the war situation, came out with some concrete solutions are concerned. In 1949, 4 main Geneva Conventions concluded. So thanks to Icrc people, the International Committee of Red Cross, and the efforts made by International Law Commission to have some specific international agreements to regulate human behavior and states' behavior during war situation as such. Look at in 1954, the Hague Convention for the Protection of Cultural Property in the event of armed force came in. What is cultural property here? This is what your Rabindranath Tagore has defined what is cultural property as. Cultural property is nothing but aesthetic value as such, love of art, medium of expression. It could be art of literature or monuments or sculpture, for example. So whatever it is actually well designed on the basis of a culture of human beings shall be looked upon. That's most important when you are actually understanding the cultural property which could be protected during armed conflict as such. If you just look into this covenant, you will have known how, in what manner you can protect cultural property during armed conflict as such. So apart from these, in 1977, two main additional protocols came in. Protocol 1, Protocol 2. So these are the protocols came out with some concrete solutions to understand the internal armed conflicts. So how internal armed conflicts could be regulated and rationalized. That's most important. And moreover, in 1978, Red Cross Fundamental Rules of International Humanitarian Law applicable in armed force. Yeah, they're also putting their efforts to rationalize war assets, and they want to understand the problems of civilians during the armed conflicts are concerned. So that's why the efforts made by International Committee of Red Cross is really marvelous. I appreciate the efforts made by these people. So that's why a series of laws have come through with you to understand laws of war is concerned. Look at in 1994, San Remo Manual on International Law applicable to armed conflicts at sea came out. In 1994, UN Convention on Safety of United Nations and Associated Persons. In 1996, the International Court of Justice advisory opinion on the legality of the threat or use of nuclear weapons, like the Nicaragua case came out with some solutions are concerned. So that's why as many as international covenants have spoken of to rationalize war situation as such. So these are the various conventions we have. Apart from earlier history in 2000, 2005, 2008, the efforts were made at the international level to understand the war as such. There are types of war. Please have a look on, and you will have known how, in what manner war can be looked upon. We have asymmetric warfare. We have biological warfare, as I've already been spoken in the last session. It was on bioterrorism, how, in what manner bioterrorism should be overcome. That's why in 1972, a convention on prohibition of biological weapons came out with some concrete solutions during the biological warfare as such. We have chemical warfare, you have cold warfare, conventional warfare, cyber warfare. These are the types of war, wars we have. Look at the asymmetric warfare, which is a conflict between belligerents of drastically different levels of military capabilities or size as such. Biological warfare or germs warfare. Some states, they use bacteria, toxins, germs, and viruses. That's why it is the use of weaponizing biological toxins or infections, agents such as bacteria, virus, and fungi. They use them for killing, civilians and enemies as well. That has to be looked upon. Look at chemical warfare. which involves the use of weaponizing chemicals in combat. Poison gas as chemical weapons was actually principally used during World War I and resulted in over 1 million estimated casualty, including more than 1 lakh civilians. This has happened even in Syria and some other countries are concerned. So that's why you have to understand chemical warfare as and when you deal with the concept of war as such. Look at Cold Warfare, you know very well, is an intense international rivalry without directly military conflict, but with a sustained threat of it, including high levels of military preparedness, expenditures, and development, and may involve active conflict by indirect means such as economic warfare and or political warfare, then counter operations, espionage, cyber warfare, proxy wars are concerned. These are the major aspects you have when you are actually running with the cold warfare as such. Look at conventional warfare. It's actually declared war, you know very well. It is to be declared war between states in which nuclear, biological, or chemical weapons which are not used or see limited deployment as such. So that's why you have to understand conventional warfare as well. Apart from these, you have a cyber warfare, which involves the actions by a nation state or international organization to attack or attempt to damage another nation's information system. Why I'm sharing all these examples. So while you're actually dealing with this, when a state has become one of the parties to some international covenants, it is their duty to follow them. This is to be called as if pacta sunt servanda. What is pacta sunt servanda? Pacta sunt servanda in the sense that pact must be respected. This is what Angeletti, an Italian jurist, has outspoken on pacta sunt servanda as such. Pacta sunt servanda in the sense that pact must be respected. Once you have become one of the parties to a convention, it is your duty to follow it. That's mandatory. The obligations are shouldered on you. Once you have become one of the member countries of a United Nations organization, you have to have as many as obligations towards others. So that's why as many as obligations are shouldered on you to understand. It is your right time to understand the pacta sunt servanda. I mean to say, pact must be respected. If something has gone wrong, then the state responsibility would come into picture. And moreover, even if you want to have some changes in some international covenants, there is a lot of scope on the basis of a rebasic stantibus, wherein it has outspoken on certain changes are concerned. Even if you need to have some changes in any convention or an agreement or treaty making conventions or law making treaties, there is a lot of scope to change the law on the basis of your own interests are concerned. This is to be called as if a rebasic stantibus as such. Rebasic stantibus. It's in Latin. However, you can understand it on the basis of a public international law as such. So apart from these, you cannot make a law which is overriding, word public opinion. If it is really overriding word public opinion, if it is against to the mankind as a whole, if it is against to international morale, under such circumstances, you have to have some standards on the basis of just cautions. This is what Article 53 that could be read out with 64 of Vienna Convention on Law of Treaties 1969, wherein it has outspoken on the concept of just cautions. Just cautions in the sense that it is a perimetry norms of general international law. Perimetry norms of general international law should be observed when you are drafting, when you are making some international agreements between states themselves. These are the standards are actually adopted at the international level when you are actually running with these treaty making process are concerned. Insurgency is a rebellion against authorities when those taking part in rebellion, and moreover, apart from insurgency, you have information warfare. Information warfare is also upcoming. Is the application of a destructive force on a large scale against information assets systems, against computers, networks that support 4 critical infrastructures like a power grid, communications, financial, and transportation. This is also one of the warfare one has to understand, like information warfare you have, insurgency war you have, nuclear warfare you have, total war you have, last but not the least, unconventional warfare. These are the types of war we have. One has to understand. See, usually there are 2 major warfares, like internal armed conflict and international armed conflict. I agree with you. I'm not disputing. Whatever I have spoken like here, they are actually based on internal and international armed conflicts are concerned. One has to understand. Look at the total war. It's a warfare whereby means possible disregarding the wars of laws of war, placing no limit on legitimate military targets are concerned. So you have to define what is war. As I said, this is what Open Aim, one of the celebrated authors of public international law, he defines what is war. War is nothing but contest between states. Yes, I agree with you. However, in these days, war is not only a contest between states, but also individuals. Individuals are also involved during war situation, and accountability shall also be fixed on them, because international personality has come through on the basis of efforts made by international code of justice as such. In international code of justice, many cases were decided to recognize individuals at the international level as such. I mean to say, on the basis of earlier history, before 1945, all individuals at the international level should be treated as if a charter or goods. It was because of efforts made by United Nations organization and its half-century enactments. We have been talking something on values of a human being that could be protected at the higher level as such. So that's why the way in which efforts made by some agencies like ICC, that's International Criminal Court, shall also be looked upon when you are actually dealing with the kinds of or types of war situation as such. And moreover, have a look on unconventional warfare. What is unconventional warfare? The opposite of conventional warfare is an attempt to achieve military victory through acquiescence, capitulation, or clandestine support for one side of an existing conflict. This is to be called as unconventional warfare. Unconventional warfare andre ನೀವು ಸ್ಪೈಯಿಂಗ್ ಏಜೆಂಟ್ಸ್ ಅಂತ ನೀವು ನೋಡಬಹುದು. ಈಗ ಗೂಢಾಚಾರ ಇರಬಹುದು, ಎಸ್ಪೇನೇಜ್ ಅಂತ ಕರಿತೀವಿ ನಾವು. ಆ ಎಸ್ಪೇನೇಜ್ ಮುಖಾಂತರ ಸ್ಪೈಯಿಂಗ್ ಏಜೆಂಟ್ಸ್ ಬರೋದು. ಸೊ ಏನ್ ಮಾಡ್ತಾರೆ, ಕ್ಲಾಂಡೆಸ್ಟೈನ್ ಮುಖ ಏನಲ್ಲ ಬೇರೆ ರೀತಿಲಿ ಚೇಂಜ್ ಮಾಡ್ಕೊಂಡು ಪಾಸ್ಪೋರ್ಟ್ ವೀಸಾನ ಬೇರೆ ಯಾರೋ ಹೆಸರಲ್ಲಿ ಸೇರ್ಕೊಂಡು ಬೇರೆ ಕಂಟ್ರೀಸ್ಗಳಲ್ಲಿ ಇನ್ಫಾರ್ಮೇಶನ್ ತಕೊಳ್ಳಿಕ್ಕೆ ಹೋಗ್ತಾರೆ. ಆತನು ಕೂಡ ಮಾಡ್ತಕ್ಕಂತ ಕೆಲಸ ಇದೆಲ್ಲ ಇಟ್ ಈಸ್ ಅಗೇನ್ಸ್ಟ್ ಟು the mankind as a whole. However, states are actually using these agents for getting information from other nations are concerned. It's possible and it is permitted under the public international law as such, as if a spying agent as such. Then you have rules of war, like what kind of rules of laws, rules of war we have. See, you cannot target civilians. Civilians shall not be killed during war situation. You have no moral right to kill women, children. You have no moral right to use children or women for sexual, interest or concern. It's totally prohibited. However, there are many instances this has happened, especially at the higher level as such, especially in Libya, Congo, Uganda, Somalia, Nigeria, war in Chechnya, war in Georgia, when there was a war between United States of America and Iraq. See, as many as American army people, they raped, Iraqi women. This has happened, abused like anything. Very recently, even in Syria, Kosovo, for example. Look at all these crises, Kosovo, even in Afghanistan also, ongoing crisis in Afghanistan, Yemen, civilian wars. If you just go through all these, recent crises at the international level, you will be wonder whether we have a law or not. That has to be looked upon. We have so many legislations at the international level, but look at the implementation level. The implementation level is very meager when you are actually running with public international law as such. So this has to be looked upon. So that's why when you are actually running with the rules of war, in nutshell, I can say rules of war have come through on the basis of these standards. You cannot, and you have no moral right to target civilians. Civilians in the sense that innocent people shall not be killed during war situation. They should be treated human. That's very, very important. And you cannot torture or inhuman treatment of detainees. You cannot torture them. You have no moral right to torture them. Inhuman treatment of detainees should be welcome. And you cannot attack hospitals and aid workers. Hospitals shall not be bulldozed during war situation. As this is what laws are emphasizing. And you have to provide a safe passage for civilians to flee. When they're fleeing, you have to give safe passes to these civilians. Civilians in the sense that innocent people should be given an opportunity to reach out to their places peaceably. This is what law is actually emphasizing. All Geneva Conventions and additional protocols. All Geneva Conventions in the sense that 1949 Geneva Conventions and additional protocols, first and second, have given some inputs to understand the rules of war as such. So that has to be looked upon. And you have to provide access to humanitarian organization. Take for example, there is a war is going on. ಈಗ ವಾರ್ ನಡೀತಾ ಇದೆ ಅಂತ ತಿಳ್ಕೊಳ್ಳಿ. ಅಂತ ಸಂದರ್ಭದಲ್ಲಿ ಕೆಲವೊಂದು ಏಜೆನ್ಸೀಸ್ಗಳಿದಾವೆ, ಇಂಟರ್ನ್ಯಾಷನಲ್ ಏಜೆನ್ಸೀಸ್, ಆರ್ಗನೈಸೇಷನ್ಸ್ ಇದಾವೆ. ಅವ್ರಿಗೊಂದು ಅವಕಾಶ ಕೊಡ್ಬೇಕು. ಅವ್ರ ಮೇಲೆ ನೀವು ದಾಳಿ ಮಾಡೋಂಗಿಲ್ಲ. ಇಟ್ ಇಸ್ ಟೋಟಲಿ ಪ್ರಾಹಿಬಿಟೆಡ್. ಯಾಕಂದ್ರೆ ICRC ಅನ್ನೋರು ಬರ್ತಾರೆ, UNHCR ಬರ್ತಾರೆ, ಹಾಗೆ ICO ಅನ್ನೋರು ಇರ್ಬೋದು, ಲೇಬರ್ ಆರ್ಗನೈಸೇಷನ್ಸ್, ಎಲ್ಲ ಏನು ಸ್ಪೆಷಲೈಸ್ಡ್ ಏಜೆನ್ಸೀಸ್ ಏನಿದಾವಲ್ಲ, it could be international agencies or regional agencies, should be given an opportunity during war situation. ಏಕಾಏಕಿ ಅವ್ರ ಮೇಲೆ ಬಾಂಬ್ ದಾಳಿ ಮಾಡಂಗಿಲ್ಲ ಅಥವಾ ಬಾಂಬ್ ದಾಳಿ ಮಾಡಂಗಿಲ್ಲ. ಯಾವುದೇ ರೀತಿಯಲ್ಲಿ ಅವರಿಗೆ ಇನ್ಹ್ಯೂಮನ್ ಟ್ರೀಟ್ಮೆಂಟ್ ಮಾಡಂಗಿಲ್ಲ. It is totally prohibited as far as Geneva Conventions are concerned. And no unnecessary or excessive loss or suffering. Unnecessary ಆಗಿ ನೀವು ಏಕಾಏಕಿ ದಾಳಿ ಮಾಡೋಗಿಲ್ಲ. ಯಾವುದೋ ಒಂದು, ಈಗ ಉದಾಹರಣೆಗೆ ಹೈ ಪಾಪ್ಯುಲೇಷನ್ ಇದ್ದಕ್ಕೆ ಹೋಗಿ ನೀವು ಬಾಂಬ್ ಅನ್ನ ಡ್ರಾಪ್ ಮಾಡೋಂಗಿಲ್ಲ. ಇಫ್ ಇಟ್ ಈಸ್ ಡ್ರಾಪ್ಡ್ ಬೈ ಯು, ಯು ಶುಡ್ ಬಿ ಬುಕ್ಡ್ ಅಂಡರ್ ವಾರ್ ಕ್ರೈಮ್. This is what ICC has got highest jurisdiction to try war crime. ಈಗ ಇತ್ತೀಚೆಗೆ ರಿಪಬ್ಲಿಕ್ ಆಫ್ ಕಾಂಗೋದಲ್ಲಿ ನಾವು ಇಬ್ಬರನ್ನ ಟಾರ್ಗೆಟ್ ಮಾಡಿ ಪನಿಷ್ಮೆಂಟ್ ಮಾಡಿ. ಉದಾಹರಣೆಗೆ ಬೆಂಬಾ ಅಂತ ಇನ್ನೊಬ್ರು ಲೆಬಾಂಗ ಅಂತ. ಬೆಂಬಾ, ಲೆಬಾಂಗ. ಈ ಲೆಬಾಂಗ ಅನ್ನೋರು ಲಾಸ್ಟ್ COVID-19 ಏನಿತ್ತಲ್ಲ 2020 ಮಾರ್ಚ್ ಅಲ್ಲಿ ಆತ ಇದು ಜೈಲಿಂದ ರಿಲೀಸ್ ಆಗ್ಬಿಡ್ತಾನೆ. 14 ವರ್ಷ ಪನಿಷ್ಮೆಂಟ್ ಅನ್ನ ನಾವು ಇಂಪೋಸ್ ಮಾಡಿದ್ವಿ ಇಂಟರ್ನ್ಯಾಷನಲ್ ಕ್ರಿಮಿನಲ್ ಕೋರ್ಟ್ ಅಲ್ಲಿ. ಹಾಗೆ ಬೆಂಬನೂ ಕೂಡ ಅಷ್ಟೇ, ಯಾಕಂದ್ರೆ ಅವರು ಆರ್ಡಿನರಿ ಏನಲ್ಲ, ಅವರೆಲ್ಲ ಮಿಲಿಟರಿಯಲ್ಲಿ ಇರ್ತಕ್ಕಂಥ ಚೀಫ್ಗಳು. They killed many people in Congo, Republic of Congo. They exposed, as many as sexual abuses against women and children. That's why ICC took very good decision to prosecute these people. ಎರಡು ಇಂಟ್ರೆಸ್ಟಿಂಗ್ ಕೇಸಸ್ ನಾನು ಹೇಳ್ತಾ ಇದ್ದೀನಿ. ಒಂದು ಪ್ರಾಸಿಕ್ಯೂಟರ್ ವರ್ಸಸ್ ಬೆಂಬಾ, ಇನ್ನೊಂದು ದಿ ಪ್ರಾಸಿಕ್ಯೂಟರ್ ವರ್ಸಸ್ ಲೆಬೆಂಗಾ. These were the two interesting cases decided by ಇಂಟರ್ನ್ಯಾಷನಲ್ ಕ್ರಿಮಿನಲ್ ಕೋರ್ಟ್. ಯಾಕಂದ್ರೆ ಇಂಟರ್ನ್ಯಾಷನಲ್ ಕ್ರಿಮಿನಲ್ ಕೋರ್ಟ್ಗೆ ನಾವು ಸಾಕಷ್ಟು ಪವರ್ಸ್ ಅನ್ನ ಕೊಟ್ಟಿದೀವಿ, ಜ್ಯೂರಿಸ್ಡಿಕ್ಷನ್ ಅನ್ನ ಕೊಟ್ಟಿದೀವಿ. ಯಾವ್ದ್ರಲ್ಲಿ ಅಂದ್ರೆ ರೋಮ್ ಸ್ಟ್ಯಾಚ್ಯೂಟ್ 1998 ಅಲ್ಲಿ. ಆದ್ರೆ ನಮ್ಮ ದೇಶದವರು ನಾವು ಸೈನ್ ಮಾಡ್ಲಿಲ್ಲ ಅಲ್ಲಿಗೆ. 1994 ಅಗ್ರಿಮೆಂಟ್ಗೆ ನಾವು ಇದು ರೋಮ್ ಸ್ಟ್ಯಾಚ್ಯೂಟ್ ಅನ್ನ ನಾವು ಸೈನ್ ಮಾಡ್ಲಿಲ್ಲ. ಆದ್ರೂ ಇಂಡೈರೆಕ್ಟ್ ಆಗಿ ಯು ಕ್ಯಾನ್ ಮೂವ್ ಟುವರ್ಡ್ಸ್ ಸೆಕ್ಯೂರಿಟಿ ಕೌನ್ಸಿಲ್ ಟು ಫೈಲ್ ಎ ಕೇಸ್ ಬಿಫೋರ್ ICC as such. ಇಂಟರ್ನ್ಯಾಷನಲ್ ಕ್ರಿಮಿನಲ್ ಕೋರ್ಟ್ ಮುಖಾಂತರ ನಾವು ಕೇಸನ್ನ ಫೈಲ್ ಮಾಡೋದು ಅವಕಾಶ ಇದೆ. ಯಾಕಂತಂದ್ರೆ ಯಾಕೆ ಇಂಟರ್ನ್ಯಾಷನಲ್ ಕ್ರಿಮಿನಲ್ ಕೋರ್ಟ್ ಬಂತು ಅಂದ್ರೆ, ಕೆಲವೊಂದು ರಾಷ್ಟ್ರಗಳಲ್ಲಿ ಈ ವಾರ್ ಕ್ರೈಮ್ಸ್ ಗೆ ಸಂಬಂಧಪಟ್ಟಂತೆ, ಜಿನೋಸೈಡಿಗೆ ಸಂಬಂಧಪಟ್ಟಂತೆ, ಅಥವಾ ಕ್ರೈಮ್ಸ್ ಅಗೇನ್ಸ್ಟ್ ಹ್ಯುಮ್ಯಾನಿಟಿಗೆ ಸಂಬಂಧಪಟ್ಟಂತೆ, ಕ್ರೈಮ್ಸ್ ಅಗೇನ್ಸ್ಟ್ ಪೀಸ್ ಆಗಿರ್ಬೋದು, ಇಂಥ ಒಂದು ಅಬ್ಯೂಸ್ಗೆ ಸಂಬಂಧಪಟ್ಟಂತೆ ಎಲ್ಲೂ ಕೂಡ ಸರಿಯಾಗಿ ಲೋಕಲ್ ಅಲ್ಲಿ ಕಾನೂನುಗಳು ಇರ್ಲಿಲ್ಲ. ಆ ಕಾರಣಕ್ಕೋಸ್ಕರ 1998 ಅಲ್ಲಿ ರೋಮ್ ಸ್ಟ್ಯಾಚ್ಯೂಟ್ ಅನ್ನ ನಾವು ಮಾಡಿದ್ವಿ. ಆ ರೋಮ್ ಸ್ಟ್ಯಾಚ್ಯೂಟ್ ಅಲ್ಲಿ ICC ಅನ್ನ ನಾವು ಕನ್ಸಿಡರ್ ಮಾಡಿ ಅದನ್ನ 2002ರಲ್ಲಿ ಎಸ್ಟಾಬ್ಲಿಷ್ ಮಾಡಿದ್ವಿ. ಅವತ್ತಿಂದ ಇವತ್ತಿಗೆ ಸಾಕಷ್ಟು ಕೇಸಸ್ ಅನ್ನ ನಾವು ನೋಡಿದೀವಿ. ತುಂಬಾ ಒಳ್ಳೆ ಎಫರ್ಟ್ ಹಾಕ್ತಾ ಇದೆ. ಯಾಕೆಂತಂದ್ರೆ ಈ ಕ್ರಿಮಿನಲ್ ಜಸ್ಟಿಸ್ ಬೇಕು ಅಂತಂತಂದ್ರೆ ನಾವು ಪನಿಷ್ಮೆಂಟ್ ಕೊಡ್ಲೇಬೇಕಾಗ್ತದೆ. ಯಾಕಂದ್ರೆ ಇಫ್ ಎಕ್ಸ್ ಹ್ಯಾಪನ್ಸ್ ದೆನ್ ವೈ ಆಟ್ ಟು ಹ್ಯಾಪನ್. ಇಫ್ ಎಕ್ಸ್ ಕಮಿಟ್ಸ್ ಎ ಕ್ರೈಮ್ ಹಿ ಶುಡ್ ಬಿ ಪ್ರಾಸಿಕ್ಯೂಟೆಡ್. ಇಂಟ್ರಾಗೇಷನ್ ಇರ್ಲಿಲ್ಲ ಅಂತಂದ್ರೆ ಎನಿಬಡಿ ಕ್ಯಾನ್ ಡು anything. That has to be looked upon. So ಹಾಗಾಗಿ ICC is also putting its efforts to overcome all these problems here and there. They intended to mitigate the hardship of war by protecting both combatants and non-combatants. Combatants ಅಂದ್ರೆ ಏನಂದ್ರೆ ಯಾರು ವಾರ್ ಸಿಚುಯೇಷನ್ ಅಲ್ಲಿ ಪಾರ್ಟಿಸಿಪೇಷನ್ ಮಾಡಿರ್ತಾರಲ್ಲ ಅವರಿಗೆ ಕಾಂಬಟೆಂಟ್ಸ್ ಅಂತ ಕರಿತೀವಿ. ಕಾಂಬಟೆಂಟ್ಸ್ ಅಂತಂದ್ರೆ ಈಗ ಆರ್ಮಿ, ಈಗ ಆರ್ಮ್ ಫೋರ್ಸ್, ಅಥವಾ ಯಾರಿಗೆ ಸರ್ಕಾರ ಐಡೆಂಟಿ ಕಾರ್ಡ್ ಕೊಟ್ಟು ವೇಜ್ ವಾರ್ ಮಾಡ್ಲಿಕ್ಕೆ ಅವಕಾಶ ಕೊಟ್ಟಿರ್ತಾವ ಅವರೆಲ್ಲ ಕಾಂಬಟೆಂಟ್ಸ್ ಬರ್ತಾರೆ ಗ್ರೂಪಿಗೆ. ನಾನ್ ಕಾಂಬಟೆಂಟ್ಸ್ ಅಂತಂದ್ರೆ ಸಿವಿಲಿಯನ್ಸ್, ಇನ್ನೋಸೆಂಟ್ ಪೀಪಲ್. ಸೊ ಇನ್ನೋಸೆಂಟ್ ಪೀಪಲ್ ಶಾಲ್ ನಾಟ್ ಬಿ ಕಿಲ್ಡ್ ಅಥವಾ ಅನ್ನೆಸೆಸರಿ ಸಫರಿಂಗ್ ಮಾಡಕ್ಕಾಗಲ್ಲ. ಇದು ಲಾ ಆಫ್ ವಾರ್ ಹೇಳುತ್ತೆ. ದೆನ್ ಸೇಫ್ ಗಾರ್ಡಿಂಗ್ ಸರ್ಟನ್ ಫಂಡಮೆಂಟಲ್ ಹ್ಯೂಮನ್ ರೈಟ್ಸ್ of persons who fall into the hands of enemy, particularly prisoners of war, the wounded, sick, children and civilian. ಈಗ ನೀವೇನು ಇಂಟರ್ನ್ಯಾಷನಲ್ ಹ್ಯೂಮನ್ ರೈಟ್ಸ್ ಅಲ್ಲಿ ಏನು ಹೇಳ್ತೀರಲ್ಲ, UDHR, ಯೂನಿವರ್ಸಲ್ ಡಿಕ್ಲರೇಷನ್ ಆಫ್ ಹ್ಯೂಮನ್ ರೈಟ್ಸ್ 1948 ಇರ್ಬೋದು. ದೆನ್ ಇಂಟರ್ನ್ಯಾಷನಲ್ ಕೋವೆನೆಂಟ್ ಆನ್ ಸಿವಿಲ್ ಅಂಡ್ ಪೊಲಿಟಿಕಲ್ ರೈಟ್ಸ್ 1966 ಇರ್ಬೋದು. ಇಂಟರ್ನ್ಯಾಷನಲ್ ಕೋವೆನೆಂಟ್ ಆನ್ ಎಕನಾಮಿಕ್, ಸೋಷಿಯಲ್ ಅಂಡ್ ಕಲ್ಚರ್ ರೈಟ್ಸ್ 1966 ಇರ್ಬೋದು. ವಿಯೆನ್ನಾ ಆಕ್ಷನ್ ಪ್ಲಾನ್ ಇರ್ಬೋದು. ಸೊ ಹಾಗೆ ಬೀಜಿಂಗ್ ಡಿಕ್ಲರೇಷನ್ 1995 ವಿಚ್ ವಾಸ್ ಆಕ್ಚುಲಿ ಎಂಫಸೈಸ್ಡ್ ಬೈ ಹಿಲರಿ ಕ್ಲಿಂಟನ್ ಇರ್ಬೋದು. ಸೊ ಆಲ್ ದೀಸ್ ಕೋವೆನೆಂಟ್ಸ್, ಐ ಮೀನ್ ಟು ಸೇ ಹಾಫ್ ಸೆಂಚುರಿ ಎನಾಕ್ಟ್ಮೆಂಟ್ಸ್ ವಿಚ್ ಆರ್ ರಿಲೈಯಿಂಗ್ ಆನ್ ದ ಪ್ರೊಟೆಕ್ಷನ್ ಅಂಡ್ ಪ್ರಮೋಷನ್ ಆಫ್ ಹ್ಯೂಮನ್ ರೈಟ್ಸ್ and fundamental freedoms without distinction with race, sex, language and religion shall also be looked upon during war situation. ಅದಕ್ಕೋಸ್ಕರ ಈ ಹ್ಯುಮ್ಯಾನಿಟೇರಿಯನ್ ಲಾ ಯಾಕೆ ಬಂತು ಅಂದ್ರೆ, ಹ್ಯುಮ್ಯಾನಿಟೇರಿಯನ್ ಲಾಗೆ ಬಹಳ ಒತ್ತು ಕೊಡ್ತಾ ಇದೀವಿ. ಯಾಕೆಂದ್ರೆ ಹ್ಯುಮ್ಯಾನಿಟೇರಿಯನ್ ಲಾ ಅಂದ್ರೆ ನನ್ನ ಅರ್ಥದಲ್ಲಿ ಹ್ಯೂಮನ್ ರೈಟ್ಸ್ ಪ್ಲಸ್ ವಾರ್, ಹ್ಯೂಮನ್ ರೈಟ್ಸ್ ಪ್ಲಸ್ ವಾರ್ ಈಸ್ ಈಕ್ವಲ್ ಟು ಹ್ಯುಮ್ಯಾನಿಟೇರಿಯನ್ ಲಾ, ದಟ್ ಟು ಇಂಟರ್ನ್ಯಾಷನಲ್ ಹ್ಯುಮ್ಯಾನಿಟೇರಿಯನ್ ಲಾ. ಹ್ಯೂಮನ್ ರೈಟ್ಸ್ plus war is equal to international humanitarian law. We need to have international humanitarian law during armed conflict as such. So what is international humanitarian law? IHL. IHL andre international humanitarian. What is international humanitarian law? It is a set of rules which seeks for humanitarian reasons to limit the effects of armed conflicts. And IHL is a branch of international law that applies to situation of armed conflicts, no matter it's known as law for and armed conflict as such. ಯಾಕಂದ್ರೆ ಅಂತಾರಾಷ್ಟ್ರೀಯ ಮಟ್ಟದಲ್ಲಿ ಏನು ಇಂಟರ್ನ್ಯಾಷನಲ್ ಹ್ಯುಮ್ಯಾನಿಟೇರಿಯನ್ ಲಾ ಇಲ್ಲ ಅಂದ್ರೆ ಬಹಳ ಸಮಸ್ಯೆಗಳಾಗ್ತವೆ. ಸೊ ಅದಕ್ಕೋಸ್ಕರ ಇಂಟರ್ನ್ಯಾಷನಲ್ ಹ್ಯುಮ್ಯಾನಿಟೇರಿಯನ್ ಲಾ was actually established on the basis of efforts made by ICRC, that's the International Committee of Red Cross, thanks to Henry Dunant institutions in which they have outspoken on the protection of human rights of civilians during war situation as such. What is the purpose of IHL? The purpose of IHL purposes of IHL are plenty. There are many, out of which I have come across with a few purposes. Kindly have a look on. It is actually reducing the unnecessary sufferings, loss and damage in time of armed conflicts. And it is a safeguarding the fundamental human rights and dignity of persons during war situation. And it is facilitating the restoration of peace. ಯಾಕಂತಂದ್ರೆ ವಿಶ್ವ ಶಾಂತಿ ಇಲ್ಲ ಅಂತಂದ್ರೆ ಯಾರು ಬದುಕಕ್ ಆಗೋದಿಲ್ಲ, ಮನುಷ್ಯನಿಗೆ ಶಾಂತಿ ಬೇಕಾಗ್ತದೆ. ಅದಕ್ಕೆ ನಾನು ಹೇಳಿದೆ, peace does not mean it is an absence of war as such. Peace means presence of justice. Fruits of justice should be shared to the people who are left out in the society as a whole. I mean to say that we have to give voice to the voiceless. However, you might have got some dichotomies between east, west, southern and northern hemisphere as such. ಸಾಕಷ್ಟಿದೆ, ದ್ವಂದ್ವಗಳು ಸಾಕಷ್ಟು. ಎಲ್ಲಾ ರಾಷ್ಟ್ರಗಳು ಒಂದೇ ಆಗ್ತವೆ ಅಂತ ಹೇಳಕ್ ಆಗೋದಿಲ್ಲ. ಕೆಲವೊಂದು ಸಂದರ್ಭದಲ್ಲಿ ಸಾಕಷ್ಟು ಡಿಫ್ರೆನ್ಸಸ್ ಆಫ್ ಒಪಿನಿಯನ್ ಇದೆ. ಯಾಕಂದ್ರೆ ಈ ಫ್ಯಾಮಿಲಿಯಲ್ಲೇ ಸಾಕಷ್ಟು ಡಿಫ್ರೆನ್ಸ್ ಇರುವಾಗ ಅಂತಾರಾಷ್ಟ್ರೀಯ ಮಟ್ಟದಲ್ಲಿ ಇಲ್ಲ ಅಂತ ಹೇಳಕ್ ಆಗೋದಿಲ್ಲ. ಇವನ್ ಫಾರ್ ಎ ಸ್ಮಾಲ್ ಥಿಂಗ್ ವಿ ಆರ್ ಕ್ವಾರ್ಲಿಂಗ್ ಈಚ್ ಅದರ್ ಅಟ್ ದಿ ಇಂಟರ್ನ್ಯಾಷನಲ್ ಲೆವೆಲ್. ಈಗ ಯಾವುದು ನ್ಯಾಚುರಲ್ ರಿಸೋರ್ಸಸ್ ಗೆ ಸಂಬಂಧಪಟ್ಟಂತೆ, ಈಗ ಔಟರ್ ಸ್ಪೇಸ್ ಇರ್ಬೋದು, ಅಥವಾ ಏರಿಯಲ್ ನ್ಯಾವಿಗೇಷನ್ ಫೆಸಿಲಿಟೀಸ್ಗೆ ಸಂಬಂಧಪಟ್ಟಂತೆ ಇರ್ಬೋದು, ಅಥವಾ ಲಾ ಆಫ್ ಸಿಗೆ ಸಂಬಂಧಪಟ್ಟಂತೆ ಇರ್ಬೋದು. ಸಾಕಷ್ಟು ದ್ವಂದ್ವಗಳು, ಸಂಘರ್ಷಗಳು, ಸವಾಲುಗಳು, ಸಮಸ್ಯೆಗಳು ಇವೆ. ಅದಕ್ಕೆ ಪರಿಹಾರ ಕಂಡುಕೊಳ್ಬೇಕಾದ್ರೆ ಅಂತಾರಾಷ್ಟ್ರೀಯ ಮಟ್ಟದಲ್ಲಿ ಒಂದು ಕಾನೂನು ಅನ್ನೋದಿದೆ, ಅದನ್ನ ನಾವು ಅರ್ಥ ಮಾಡ್ಕೋಬೇಕು. ಸೊ ಹಾಗಾಗಿ ನಾನು ಇಲ್ಲಿ ಹೇಳಿಕೆ ಇಷ್ಟಪಡ್ತೀನಿ. ಅದ್ರ ಜೊತೆಗೆ ವೆನ್ ಡಸ್ IHL ಅಪ್ಲೈ? ಯಾವಾಗ ಹ್ಯುಮ್ಯಾನಿಟೇರಿಯನ್ ಲಾ ಅಪ್ಲೈ ಆಗುತ್ತೆ ಅಂದ್ರೆ ಡ್ಯೂರಿಂಗ್ ದ ಸಿಚುಯೇಷನ್ಸ್ ಆಫ್ ಇಂಟರ್ನಲ್ and international armed conflicts. During internal armed conflicts, IHL does not apply in situation of rights, internal tensions, disturbance. ಕೆಲವೊಂದು ಸಂದರ್ಭದಲ್ಲಿ ರೈಟ್ಸ್ ಅಥವಾ ಟೆನ್ಷನ್ಸ್ ಅಥವಾ ಡಿಸ್ಟರ್ಬೆನ್ಸ್ ಇದ್ದಾಗ ಅಂತ ಸಂದರ್ಭದಲ್ಲಿ ಇಂಟರ್ನ್ಯಾಷನಲ್ ಹ್ಯುಮ್ಯಾನಿಟೇರಿಯನ್ ಅಪ್ಲೈ ಮಾಡಕ್ ಬರೋದಿಲ್ಲ. ಎಕ್ಸೆಪ್ಷನಲಿ in some circumstances certain international humanitarian rules apply at all times in all circumstances, like peace time and UN operations. ಯಾವಾಗ ಯುನೈಟೆಡ್ ನೇಷನ್ಸ್ ಆರ್ಗನೈಸೇಷನ್ ಆಪರೇಷನ್ಸ್ ಇದ್ದೆ ಅಂತ ಸಂದರ್ಭದಲ್ಲಿ, ಈ ಪೀಸ್ ಕೀಪಿಂಗ್ ಆಪರೇಷನ್ಸ್ ಇದ್ದ ಸಂದರ್ಭದಲ್ಲಿ ನಾವು ಈಗ IHL ಅನ್ನ ಅಪ್ಲೈ ಮಾಡ್ಬೋದು. ಉದಾಹರಣೆಗೆ ನಾರ್ತ್ ಈಸ್ಟ್ ಗೆ ಸಂಬಂಧಪಟ್ಟಂತೆ ಕೆಲವೊಂದು ಎಲ್ಲೋ ಒಂದ್ ಕಡೆಗೆ ವೈಲೇಷನ್ ಆಫ್ ಹ್ಯೂಮನ್ ರೈಟ್ಸ್ ಬಂದಾಗ ಅಂತ ಸಂದರ್ಭದಲ್ಲಿ ಯುನೈಟೆಡ್ ನೇಷನ್ಸ್ ಆರ್ಗನೈಸೇಷನ್ ಕ್ಯಾನ್ ಇಂಟರ್ವ್ಯೂನ್ ಇನ್ ದಿ ಅಫೇರ್ಸ್ ಆಫ್ ದೀಸ್ ಸ್ಟೇಟ್ಸ್ ಆರ್ ಕನ್ಸರ್ನ್. ಬಟ್ ನೀವು ಕಾನೂನಲ್ಲಿ ಹೇಳ್ಬೇಕು ಅಂತಂದ್ರೆ Article 2, paragraph 7 of UN Charter, it is prohibited. However, there are some circumstances wherein which United Nations organization can intervene in the affairs of another state to restore or maintain international peace and security as well. ವಿಶ್ವ ಶಾಂತಿಯನ್ನ ಕಾಪಾಡುವ ಒಂದು ಸಂದರ್ಭದಲ್ಲಿ ವಿಶ್ವಸಂಸ್ಥೆ ಎಂತ ಸಂದರ್ಭದಲ್ಲೂ ಕೂಡ ರಾಷ್ಟ್ರದಲ್ಲಿ ಹಸ್ತಕ್ಷೇಪ ಮಾಡಬಹುದು ಅನ್ನೋದನ್ನ ನಾವು ಕಾನೂನಲ್ಲಿ ನೋಡಿದ್ವಿ. ಸೊ ಅದ್ರ ಜೊತೆಗೆ ಟು ಹೂಮ್ ಡಸ್ IHL ಅಪ್ಲೈ? ನಾವು ಎರಡು ಅಂಶಗಳನ್ನು ನೋಡ್ತೀವಿ, ಒಂದು ಕಾಂಬಟೆಂಟ್ಸ್, ಇನ್ನೊಂದು ಸಿವಿಲಿಯನ್ಸ್ ಅಂತ. ಈಗಾಗಲೇ ನಾನು ಹೇಳಿದ್ದೀನಿ, IHL ರೆಕಗ್ನೈಸ್ 2 categories of persons in armed conflict. ಯಾವುದೇ ಒಂದು ಯುದ್ಧ ಆಗ್ಬೇಕಾದ್ರೆ ಎರಡು ಅಂಶಗಳನ್ನು ನಾವು ನೋಡ್ಬೇಕು. ಒಂದು ಕಾಂಬಟೆಂಟ್ಸ್, ಇನ್ನೊಂದು ನಾನ್ ಕಾಂಬಟೆಂಟ್ಸ್ ಅಂತ ಕರಿತೀವಿ, ಅದನ್ನ ಸಿವಿಲಿಯನ್ಸ್ ಅಂತ ಕರಿತೀವಿ. ನೀವು ಕಾಂಬಟೆಂಟ್ಸ್ ಅನ್ನಗೆ ಕ್ಯಾನ್ ಬಿ ಅಟ್ಯಾಕ್, ಅವ್ರ ಮೇಲೆ ಅಟ್ಯಾಕ್ ಮಾಡ್ಬೋದು ನೀವು. Combatants have the right to participate directly in hostiles ಅಂತಂದ್ರೆ ಯಾವುದೇ ಒಂದು ಯುದ್ಧ ಆಗುವಾಗ ಬೇಸ್ಡ್ ಆನ್ ದಿ ID cards issued by the government, they can participate directly in hostile relations between states themselves and can be attacked. ಅವ್ರ ಮೇಲೆ ಅಟ್ಯಾಕ್ ಮಾಡಬಹುದು, ಅವಕಾಶ ಇದೆ. ಬಟ್ ಒನ್ ಟೈಮ್ ನೀವೇನಾದ್ರು ಅವ್ರನ್ನ ಹಾಸ್ಟೈಲ್ ರಿಲೇಶನ್ಶಿಪ್ ತಗೊಂಡ್ರೆ ಅವ್ರ ಮೇಲೆ ಯಾವುದೇ ರೀತಿ ಟಾರ್ಚರ್ ಮಾಡಂಗಿಲ್ಲ, ಇನ್ಹ್ಯೂಮನ್ ಟ್ರೀಟ್ಮೆಂಟ್ ಕೊಡಂಗಿಲ್ಲ. ನಾನು ಕೆಲವೊಂದು ಸ್ಲೈಡ್ಸ್ ಅನ್ನ ತೋರಿಸ್ತೀನಿ, ಆ ಸ್ಲೈಡ್ಸ್ ನೋಡಿದಾಗ ನಿಮಗೆ ಗೊತ್ತಾಗ್ತದೆ ಹೇಗೆ. Then civilians are protected. All civilians like refugees, internally displaced persons, orphans, women, children, LGBT, vulnerable sections of the society ಅಥವಾ civilians or innocent people ಇದಾರಲ್ಲ, they're all well protected under the umbrella of Vienna Convention on Law of War 1949 and Additional Protocol 1977 as such. There are some fundamental rules of IHR. Look at, you have to ensure human treatment of persons not taking part in hostile relations, and you have no moral right to kill or injure protected persons. ಈ protected persons ಅಂತ ಇರ್ತಾರೆ. ಉದಾಹರಣೆಗೆ ಯಾರು ಅಂದ್ರೆ ಈಗ ಅಂಬಾಸಿಡರ್ಸ್ ಇರ್ಬೋದು, ಹೈ ಕಮಿಷನ್ಸ್ ಇರ್ಬೋದು, ಅಥವಾ ಕಾನ್ಸುಲೇಟ್ ಜನರಲ್ ಇರ್ತಾರೆ, ಅಥವಾ ರೆಪ್ರೆಸೆಂಟೇಟಿವ್ ಆಫ್ ದ ಗವರ್ಮೆಂಟ್ ಇರ್ಬೋದು. ಅವರೆಲ್ಲ ಪ್ರೊಟೆಕ್ಟೆಡ್ ಪರ್ಸನ್ಸ್ ಹೂ ಹ್ಯಾವ್ ಗಾನ್ ದೇರ್ ಫಾರ್ ಕಂಪ್ಲೀಟಿಂಗ್ ದೇರ್ ಅಫಿಷಿಯಲ್ ವರ್ಕ್. ಅವ್ರ ಮೇಲೆ ನೀವು ದಾಳಿ ಮಾಡಂಗಿಲ್ಲ. ಇಟ್ ಇಸ್ ಟೋಟಲಿ ಪ್ರೊಹಿಬಿಟೆಡ್ ಆಸ್ ಫಾರ್ as law is concerned. ಆಮೇಲೆ ಯು ಹ್ಯಾವ್ ಟು ಎನ್ಶ್ಯೂರ್ human treatment of persons not taking part in hostile relations, and then you have to collect care for wounded and sick. ಎಲ್ಲಿ ಕೆಲವು ಸಂದರ್ಭದಲ್ಲಿ ಈಗ ನೀವು ನೋಡಿದ್ರಿ, ಈಗ ಕಳಿಂಗ ವಾರದಲ್ಲಿ ಅಶೋಕ he regretted himself. ಅದಕ್ಕೋಸ್ಕರ ಅವರು ಕೊನೆಗೆ ಬೌದ್ಧ ಧರ್ಮವನ್ನ ಸ್ವೀಕಾರ ಮಾಡ್ತಾರೆ, ಯಾಕೆಂದ್ರೆ ನಾನು ಮಾಡಿದ ತಪ್ಪು ಅಂತ. ಸೊ ಹಾಗಾಗಿ ಈ ಯಾವುದೇ ಹಿಂದೆ ಏನಾಗ್ತಿತ್ತು ಅಂದ್ರೆ, ಯಾವುದೇ ಒಂದು ಬ್ಯಾಟ್ಲು ಅಥವಾ ವಾರ ಆದಾಗ ಈ ವುಂಡೆಡ್ ಅಂಡ್ ಸಿಕ್ ನಾವು ನೋಡ್ತಾನೆ ಇರ್ಲಿಲ್ಲ. ಎಷ್ಟೋ ವರ್ಷ ಆದ್ಮೇಲೆ ಅಲ್ಲೇ ತೀರ್ಕೊಂಡ್ಬಿಡೋದು, ಅದೇ ಜಾಗದಲ್ಲಿ. ಒಂದ್ ರೀತಿಲಿ ಸ್ಮಶಾನ ಆದಂಗ ಆಗ್ಬಿಡೋದು, ಒಂಥರ ಗ್ರೇವ್ ಯಾರ್ಡ್ ಆದಂಗ ಆಗ್ಬಿಡೋದು, ಅಥವಾ ಕ್ರಿಮಿಟೋರಿಯಂ ಆದಂಗ ಆಗ್ಬಿಡೋದು. ಸೊ ಈ ಹಿಸ್ಟ್ರಿಯನ್ನು ನೋಡ್ಕೊಂಡು ನಾವು ಅಂತಾರಾಷ್ಟ್ರೀಯ ಮಟ್ಟದಲ್ಲಿ ಕೆಲವೊಂದು ಕಾನೂನುಗಳನ್ನ ಮಾಡಿದ್ವಿ. ಹಾಗಾಗಿ ಯು ಹ್ಯಾವ್ ಟು ಕಲೆಕ್ಟ್ ಅಂಡ್ ಕೇರ್ ಫಾರ್ ವುಂಡೆಡ್ ಅಂಡ್ ಸಿಕ್. ಅಂತ ಸಂದರ್ಭದಲ್ಲಿ ಆತಗೇನಾದ್ರು ಗಾಯ ಆಗಿದ್ರೆ, ತೊಂದರೆ ಏನಾಗಿದೆ ಅಂತ, ಕೈನೋ ಕಳ್ಕೊಂಡಿದ್ದ ಅಂತ ಸಂದರ್ಭದಲ್ಲಿ ಅವನನ್ನ ಕೇರ್ ಮಾಡ್ಬೇಕಾಗುತ್ತೆ. ದಟ್ ಈಸ್ ಯುವರ್ ಡ್ಯೂಟಿ. ಅಂಡ್ ದಟ್ ಯು ಹ್ಯಾವ್ ಟು ರೆಸ್ಪೆಕ್ಟ್ ಲೈಫ್ಸ್ ಅಂಡ್ ಡಿಗ್ನಿಟಿ ಆಫ್ ಕ್ಯಾಪ್ಚರ್ಡ್ ಕಾಂಬಟೆಂಟ್ಸ್ ಅಂಡ್ ಸಿವಿಲಿಯನ್ಸ್. ಕ್ಯಾಪ್ಚರ್ ಮಾಡಿದ್ರೆ ಅವ್ರನ್ನ ಅವಮಾನ ಮಾಡಂಗಿಲ್ಲ ಅವ್ರಿಗೆ. ಹಾಗಾಗಿ ಯು ಹ್ಯಾವ್ ಟು ರೆಸ್ಪೆಕ್ಟ್ ಫಂಡಮೆಂಟಲ್ ಜುಡಿಷಿಯಲ್ ಗ್ಯಾರಂಟೀಸ್ ಡ್ಯೂರಿಂಗ್ ಟ್ರಯಲ್ಸ್ ಅಂಡ್ ಪ್ರೊಸೀಡಿಂಗ್ಸ್. ಆತನ ಪ್ರಾಸಿಕ್ಯೂಟ್ ಮಾಡ್ಬೇಕಾದ್ರೆ ನಿಮಗೆ ಗೊತ್ತಿದೆ, ಫೇರ್ ಟ್ರಯಲ್ ಈಸ್ ಆಲ್ಸೋ ಎ ಫಂಡಮೆಂಟಲ್ ರೈಟ್ ದಟ್ ಹ್ಯಾಸ್ ಟು ಬಿ ಲುಕ್ಡ್ ಅಪಾನ್. ಸುಮ್ಮನೆ ಅವನ ಬೇಕಾಬಿಟ್ಟಿ ಟಾರ್ಗೆಟ್ ಮಾಡಿ ಆತನಿಗೆ ಪನಿಷ್ಮೆಂಟ್ ಕೊಡಂಗಿಲ್ಲ. ಇಟ್ ಇಸ್ ಟೋಟಲಿ ಪ್ರೊಹಿಬಿಟೆಡ್. ಅಂಡ್ ದ ಚಾಯ್ಸ್ ಆಫ್ ಮೀನ್ಸ್ ಅಂಡ್ ಮೆಥಡ್ಸ್ ಆಫ್ ವಾರ್ಫೇರ್ ಈಸ್ ನಾಟ್ ಅನ್ಲಿಮಿಟೆಡ್. ಅಂಡ್ ಡಿಸ್ಟಿಂಕ್ಷನ್ ಬಿಟ್ವೀನ್ ಕಾಂಬಟೆಂಟ್ ಸಿವಿಲಿಯನ್ಸ್ ಅಟ್ ಆಲ್ ಟೈಮ್ಸ್. ನೀವು ಡಿಸ್ಟಿಂಕ್ಷನ್ ಮಾಡಬೇಕು. ಬಾಂಬ್ ಹಾಕೋಕ್ಕಿಂತ ಮುಂಚೆ ಯಾವುದೇ ಆಗಿರ್ಬೋದು, ಇಟ್ ಕುಡ್ ಬಿ ಕೆಮಿಕಲ್, ಬಯಾಲಜಿಕಲ್, ಸಮಥಿಂಗ್ ಎಲ್ಸ್, ಲೇಸರ್, ಯಾವುದೇ ಬಾಂಬ್ ಅನ್ನು ಹಾಕುವಾಗ ನೀವು ಡಿಸ್ಟಿಂಕ್ಷನ್ ಮಾಡ್ಬೇಕು. ಯಾಕಂದ್ರೆ ಆತ ಸಿವಿಲಿಯನ್ಸ್, ವಿಮೆನ್ ಇದಾರೋ, ಚಿಲ್ಡ್ರನ್ ಇದಾವ, ಹಾಸ್ಪಿಟಲ್ಸ್ ಇದಾರ, ಅಥವಾ ಡ್ಯಾಮ್ಸ್ ಇದಾವ, ರಿಸರ್ವೈರ್ಸ್ ಇದಾವ, ಏನು ಆಮೇಲೆ ಕಲ್ಚರಲ್ ಪ್ರಾಪರ್ಟಿ ಇದೆಯಾ, ಅದೆಲ್ಲ ನೋಡ್ಬೇಕು. ಏಕಾಏಕಿ ಬಂದು ಮೈಸೂರು ಪ್ಯಾಲೇಸ್ ಮೇಲೆ ಬಾಂಬ್ ಹಾಕಕ್ಕಾಗಲ್ಲ. ನೀವು ಹೋಗಿ KRS ಮೇಲೆ ಬಾಂಬ್ ಹಾಕಕ್ಕಾಗಲ್ಲ, ಅಥವಾ ತಾಜ್ ಮಹಲ್ ಮೇಲೆ ಬಾಂಬ್ ಹಾಕಕ್ಕಾಗಲ್ಲ. ಇಟ್ ಇಸ್ ಟೋಟಲಿ ಪ್ರೈವೇಟ್. ಅಥವಾ ಯಾವ್ದು ಅಪೋಲೋನೋ ಕೊಲಂಬಿಯಾ ಏಷ್ಯಾ ಹಾಸ್ಪಿಟಲ್ ಮೇಲೆ ಬಾಂಬ್ ಹಾಕಕ್ಕಾಗಲ್ಲ. ಇಟ್ಸ್ ಟೋಟಲಿ ಪ್ರೈವೇಟೆಡ್ ಆಸ್ ಫಾರ್ as law is concerned. So these are the things you have to understand. He is getting some information inhumanly. You shall not be tortured. ಕುಡಿಸಿ ಅವನಿಗೆ ಹಿಂಸೆಯಿಂದ ನೀವು ಇನ್ಫಾರ್ಮೇಶನ್ ತಗೊಳಂಗಿಲ್ಲ. ಇಟ್ ಇಸ್ ಟೋಟಲಿ ಪ್ರೊಹಿಬಿಟೆಡ್. ಮಿನಿಮಮ್ ಸ್ಟ್ಯಾಂಡರ್ಡ್ಸ್ ಶುಡ್ ಬಿ ರೆಸ್ಪೆಕ್ಟೆಡ್ ಡ್ಯೂರಿಂಗ್ ವಾರ್ ಸಿಚುಯೇಷನ್ ಆಸ್ ಸಚ್. ಹೀಗೆ ಈಗ ಡಾಗ್ ಬಿಟ್ಟು ಈಗ ದಿಸ್ ಹಸ್ ಹ್ಯಾಪೆಂಡ್ ಇನ್ ಇರಾಕ್ ಅಂಡ್ ಅಮೆರಿಕನ್ ವಾರ್. American army people, he was actually getting some information from him by showing dog. ಒಂಥರ ಭಯದ ವಾತಾವರಣ ಆಗುತ್ತೆ. ಪ್ಯಾನಿಕ್ ಆಗಿ ನೀವು ಇನ್ಫಾರ್ಮೇಶನ್ ತಗೊಳಕ್ ಬರಂಗಿಲ್ಲ. ಬಟ್ ಆ ತಕೊಂಡ್ರು ಕೂಡ ನೀವು ವಾರ್ ಕ್ರೈಮ್ ಎಲ್ಲ ಅವನ ಮೇಲೆ ಕೇಸನ್ನು ಮಾಡ್ಬೋದು ಬಿಫೋರ್ ICC. ಟಾರ್ಚರ್ ಶಾಲ್ ನಾಟ್ ಬಿ ಗಿವನ್, ಲೈಕ್ ಎಲೆಕ್ಟ್ರಿಕ್ ವೈರ್ ಕೊಟ್ಟು ಅವನನ್ನ ಇನ್ಫಾರ್ಮೇಶನ್ ತಗೊಳಂಗಿಲ್ಲ, ಇನ್ಹ್ಯೂಮನ್ ಆಗಿ ಅವನಿಗೆ ಟ್ರೀಟ್ಮೆಂಟ್ ಮಾಡಿ. ಇಟ್ ಇಸ್ ಟೋಟಲಿ ಪ್ರೈಬಿಟೆಡ್ ಆಸ್ ಫಾರ್ as law. This has happened in Iraq also. These people were getting some information from a lady as such. ಅವಳು ಬಟ್ಟೆನೆಲ್ಲ ಬಿಚ್ಚಿ ಅವಳು ಇನ್ಹ್ಯೂಮನ್, ಈಗಲೂ ಇಂಟರ್ನೆಟ್ ಅಲ್ಲಿ ಇದೆ, ನೀವು ಡೌನ್ಲೋಡ್ ಮಾಡ್ಬೋದು. ಅಷ್ಟು ಇಂಥ ಇನ್ಹ್ಯೂಮನ್ ವ್ಯವಸ್ಥೆ ನಮ್ಮ ಒಂದು ಪ್ರಪಂಚದಲ್ಲಿದೆ ಅಂದಕ್ಕೆ ಇವೆಲ್ಲ ಸಾಕ್ಷಿಗಳು. ಯು ಹ್ಯಾವ್ ಟು ಅಂಡರ್ಸ್ಟ್ಯಾಂಡ್. And see, international criminal responsibility. See how international criminal responsibility shall be looked upon. So based on earlier history, it was because of efforts made at the international level. We are running with all these development like Tokyo, Nuremberg trials ಅಲ್ಲಿ ನಾವು ಬಹಳ ಸ್ಟೆಪ್ಸ್ ಅನ್ನ ತಗೊಂಡ್ವಿ. ಹಾಗೆ ನಿಲ್ಲೇ ನೋಡಿ, ಇಂಟರ್ನ್ಯಾಷನಲ್ ಕ್ರಿಮಿನಲ್ ಟ್ರಿಬ್ಯುನಲ್ ಫಾರ್ ಯುಗೋಸ್ಲಾವಿಯಾ ಅಂಡ್ ರುವಾಂಡಾ 1993 1994 ಅಲ್ಲಿ we could be established all these international criminal tribunals for prosecuting war criminals, crimes against humanity, crimes against peace, and genocide assets. This has happened. This is one of the interesting aspects that shall be looked upon. You have to understand Nuremberg trial. ಈ ಟ್ರಯಲ್ ಅಲ್ಲಿ ನಾವು ಹೈಕ್ಮ್ಯಾನ್ ಅಂತ ನಿಮಗೆ ಗೊತ್ತಿರ್ಬೋದು, ಹೈಕ್ಮ್ಯಾನ್ ಅಂತ ಹಿಟ್ಲರ್ ಫಾಲೋವರ್ ಅವನು. Based on his command, he killed many civilians during the Second World War. ಆತನ ಹಿಡಿದು ಈ ಒಂದು ನ್ಯೂರೆಂಬರ್ಗ್ ಟ್ರಯಲ್ ಅಲ್ಲಿ ನಾವು ಪ್ರಾಸಿಕ್ಯೂಟ್ ಮಾಡಿ ಪನಿಷ್ಮೆಂಟ್ ಮಾಡಿ ಹ್ಯಾಂಗ್ ಮಾಡ್ತೀವಿ. This has happened in international scenario as such. Then ICT, these are the statutes we have. A commander responsibility and superior orders. See, a commander is responsible if he commits or orders the commission of a war crime as such, if he fails to take all possible steps to prevent, punish war crime as such. So that's why commander is also responsible. ನಾನು ಹೇಳಿದೀನಿ ಹೋಗಿ ಸಿವಿಲಿಯನ್ಸ್ ಅನ್ನ ಮೇಲೆ ಬಾಂಬ್ ಹಾಕಿ ಅನ್ನಕ್ಕಾಗಲ್ಲ. Commander should know the humanity. I mean to say rules of humanity should be respected during war situation as such. He should know the situation. Based on that, he can order them, order his followers to target civilians are concerned. And implementation obligations during peacetime, and you have to respect Red Cross emblems. Red Cross emblems ಅಂತಂದ್ರೆ ರೆಡ್ ಕ್ರಾಸ್ ಎಂಬ್ಲಮ್ ಅವರೆಲ್ಲ ಮೆಡಿಕಲ್ ಫೆಸಿಲಿಟೀಸ್ ಕೊಡ್ಲಿಕ್ಕೆ ಬರ್ತಾರೆ ವಾರ್ ಸಿಚುವೇಶನ್ ಅಲ್ಲಿ. ಸೊ ಅಂತ ಸಂದರ್ಭದಲ್ಲಿ ರೆಡ್ ಕ್ರಾಸ್ ಮೇಲೆ ದಾಳಿ ಮಾಡಂಗಿಲ್ಲ. ಅಥವಾ ನೀವು ಈಗ ಯಾರು ಮೀಡಿಯಾದವ್ರು ಬರ್ತಾರೆ, ಅವ್ರ ಫೋಟೋ ತೆಗೆಯುವಾಗ ಅವ್ರ ಮೇಲೆ ಬಾಂಬ್ ಅನ್ನ ಹಾಕಂಗಿಲ್ಲ. ಇಟ್ಸ್ ಟೋಟಲಿ ಪ್ರೊಹಿಬಿಟೆಡ್ as far as Geneva conventions are concerned. You have to disseminate conventions. ಟೀಚ್ ಮಾಡ್ಬೇಕು ಅವ್ರಿಗೆ, ಆರ್ಮಿಗಳಿಗೆ ಸರಿಯಾಗಿ ಸ್ಟಡಿ ಮಾಡಿಸ್ಬೇಕು, ಒಂದು ಸೆಮಿನಾರ್ಸ್ಗಳು ಮಾಡಿಸ್ಬೇಕು, ಕಾನ್ಫರೆನ್ಸ್ಗಳು ಮಾಡಿಸ್ಬೇಕು, ವರ್ಕ್ಶಾಪ್ಸ್ ಮಾಡಿಸ್ಬೇಕು, ಸಿಂಪೋಸಿಯಮ್ಸ್ ಮಾಡಿಸ್ಬೇಕು, ಅಥವಾ ಇಂಟರಾಕ್ಷನ್ ಮಾಡ್ಕೊಂಡು ಅವ್ರಿಗೆಲ್ಲ ಟ್ರೈನ್ ಅಪ್ ಕೊಡ್ಬೇಕಾಗ್ತೈತಿ. That's one of the responsibilities shouldered on any state to disseminate these conventions are concerned. You have to enact penal legislations at the local level. You have to translate treaties into national languages. ಕೆಲವೊಬ್ಬರಿಗೆ ಭಾಷೆ ಗೊತ್ತಿರೋದಿಲ್ಲ. ಈಗ ಎಲ್ಲರಿಗೂ ಇಂಗ್ಲಿಷ್ ಬರೋದಿಲ್ಲ, ಎಲ್ಲರಿಗೂ ಕನ್ನಡ ಬರೋದಿಲ್ಲ, ತಮಿಳು ಬರೋದಿಲ್ಲ, ತೆಲುಗು ಬರೋದಿಲ್ಲ ಅಂತ. ಸೊ ಆ ಸಂದರ್ಭದಲ್ಲಿ ಲೋಕಲ್ ಲ್ಯಾಂಗ್ವೇಜ್ಗೆ ಟ್ರಾನ್ಸ್ಲೇಷನ್ ಮಾಡ್ಬೇಕು. ಯಾಕಂದ್ರೆ ಕೆಲವೊಂದು ಕನ್ವೆನ್ಷನ್ಸ್ ಗಳು ಸ್ಪ್ಯಾನಿಷ್ ಅಲ್ಲಿ ಇದೆ, ಆಮೇಲೆ ಫ್ರೆಂಚ್ ಅಲ್ಲಿ ಇದೆ, ಜರ್ಮನ್ ಅಲ್ಲಿ ಇದೆ, ಇಂಗ್ಲಿಷ್ ಅಲ್ಲಿ ಇದೆ. ಸೊ ಅಂತ ಕನ್ವೆನ್ಷನ್ಸ್ ಗಳನ್ನ ಲೋಕಲ್ ಲ್ಯಾಂಗ್ವೇಜ್ಗೆ ಟ್ರಾನ್ಸ್ಲೇಟ್ ಮಾಡ್ಬೇಕು. ಕನ್ನಡ ಲ್ಯಾಂಗ್ವೇಜ್ಗೆ ಟ್ರಾನ್ಸ್ಲೇಟ್ ಮಾಡಿದ್ರೆ ಎಲ್ರಿಗೂ ಅರ್ಥ ಆಗತ್ತೆ, ಎಲ್ಲರೂ ತಿಳ್ಕೊತಾರೆ. ಯುದ್ಧದ ಕಾನೂನು ಅಂದ್ರೇನು, ಲಾ ಆಫ್ ವಾರ್ ಅಂದ್ರೇನು, ಹೌ ಎ ಲಾ ಆಫ್ ವಾರ್ ಶೆಲ್ ಬಿ ಲುಕ್ಡ್ ಅಪಾನ್ ಅನ್ನೋದನ್ನ ಕಲಿಬಹುದು, ಅವಕಾಶ ಇದೆ. ಅಂಡ್ ಲೀಗಲ್ advisors in the armed forces shall be looked upon, and duty of commander shall also be looked. And moreover, mutual assistance in criminal matter is to be observed between states themselves. Of course, there are some challenges at the international level. We have weak record of ratification, lack of national implementation legislations. We have lack of awareness, different legal systems. ಕೆಲವೊಂದು ಏನಾಗ್ತದೆ ಅಂದ್ರೆ, ಈ ಅಮೆರಿಕನ್ ಕಾನ್ಸ್ಟಿಟ್ಯೂಷನ್, ಫ್ರೆಂಚ್ ಕಾನ್ಸ್ಟಿಟ್ಯೂಷನ್, ಸ್ವಿಸ್ ಕಾನ್ಸ್ಟಿಟ್ಯೂಷನ್ ಇರ್ಬೋದು, ನಮ್ಮಲ್ಲಿ ಹತ್ತಿರದಲ್ಲೇ ಚೈನಾ, ಶ್ರೀಲಂಕಾ, ಹೀಗೆ ನಮ್ಮ ದೇಶದ ಸಂವಿಧಾನನ ತಕೊಳ್ಳಿ. ಈ ಬೇರೆ ಬೇರೆ ಸಂವಿಧಾನಗಳು ಆಯಾ ಜನರಿಗೆ ತಕ್ಕಂತೆ ಬಂದಿರ್ತವೆ. ಹಾಗಾಗಿ ಈ ಡಿಫ್ರೆನ್ಸ್ ಮಾಡುವಾಗ ಇದು ಒಂದು ಕೂಡ ಚಾಲೆಂಜ್ ಆಗಿದೆ. ಹಾಗಾಗಿ ಯಾವುದೇ ಒಂದು ಕಾನೂನನ್ನು ಮಾಡುವಾಗ ಯು ಹ್ಯಾವ್ ಟು ಲುಕ್ ಇವನ್ ಫ್ರಮ್ ದಿ perspective of public international law such. So these are the things which shall be looked upon, and these are the photos, so you just go through them. There are 3 fundamental rules that has to be, you have to follow methods and means, and it is prohibited to deliberately attack on civilian population. Distinction must be made at all levels. Look at how, in what manner the committee of a Red Cross has been aiding each one of them to understand the humanitarian law during war situation as such. And these are the medical services. All these things shall be looked upon. ಯಾಕೆ ನಾನು ತೋರಿಸ್ತಾ ಇದ್ದೀನಿ ಅಂದ್ರೆ, ಒಂದು ವಾರ ನಡೀತಾ ಇದೆ ಅಂದ್ರೆ ಅಂತ ಸಂದರ್ಭದಲ್ಲಿ ಈ ಎಂಬ್ಲಮ್ಸ್ ಅನ್ನ ಕೊಡ್ಬೇಕು, ಆ ಪ್ಲಸ್ ಅದೆಲ್ಲ ಕೊಡ್ಬೇಕು. ಎಂಬ್ಲಮ್ಸ್ ಕೊಟ್ರೆ ಗೊತ್ತಾಗ್ತದೆ ಮೇಲೆ ಟಾರ್ಗೆಟ್ ಮಾಡಿ ಈಗ ಬಾಂಬನ್ನ ಡ್ರಾಪ್ ಮಾಡುವಾಗ ಅಥವಾ ಟಾರ್ಗೆಟ್ ಮಾಡುವಾಗ ಆ ಎನಿಮಿಗೆ ಗೊತ್ತಾಗ್ಬೇಕು, ಇದು ಹಾಸ್ಪಿಟಲ್ ಝೋನು, ಈ ಝೋನ್ ಮೇಲೆ ನಾವು ಅಟ್ಯಾಕ್ ಮಾಡೋಂಗಿಲ್ಲ ಅಂತ ರೂಲ್ಸ್ ಇದೆ. ಅದ್ ನಾವು ನೋಡ್ಬೇಕಾಗುತ್ತೆ. ವಾಟ್ ದ ICRC ಈಸ್ ನಾಟ್. ಈಗ ಏನಾಗೈತಿ ಅಂತಂದ್ರೆ, ದರ್ ಆರ್ ಸಮ್ ಮಿಸ್ಕಾನ್ಸೆಪ್ಷನ್. ಇಂಟರ್ನ್ಯಾಷನಲ್ ಕಮಿಟಿ ಆಫ್ ರೆಡ್ ಕ್ರಾಸ್ ಅಂದ್ರೆ ಯುನೈಟೆಡ್ ನೇಷನ್ಸ್ ಆರ್ಗನೈಸೇಷನ್ ಏಜೆನ್ಸಿ ಅಂತ ಕರೀತಾರೆ, ಅದು ಅಲ್ಲ. ಅದಕ್ಕೆ ನಾನು ನೋಡಿ, ಇಟ್ಸ್ ನಾಟ್ ಅಟ್ ಆಲ್ ಯುನೈಟೆಡ್ ನೇಷನ್ ಆರ್ಗನೈಸೇಷನ್ ಆರ್ NGO, ನಾನ್ ಗವರ್ಮೆಂಟಲ್ ಆರ್ಗನೈಸೇಷನ್ ಅಲ್ಲ, ಯುನೈಟೆಡ್ ನೇಷನ್ ಆರ್ಗನೈಸೇಷನ್ ಅಲ್ಲ. ICRC is a private and independent organization with headquarters in Geneva, Switzerland, which are set up. ಅಲ್ಲಿ ಸೆಟಪ್ ಆಗಿ ICRC. Cultural property should also be protected during war situation. ಈ ತಾಜ್ ಮಹಲ್ಗೆ ಹೋಗಿ ಬಾಂಬ್ ಹಾಕಾಗಿಲ್ಲ, ಅದಕ್ಕೋಸ್ಕರ ನಾನು ಲಾ ಆಫ್ ವಾರ್ ಅನ್ನ ತಮಗೆ ಹೇಳಲಿಕ್ಕೆ ಇಷ್ಟಪಟ್ಟೆ. ಹೀಗೆ ಕೆಲವೊಂದು ಸಿವಿಲಿಯನ್ ಪಾಪ್ಯುಲೇಷನ್ಗೆ ಹೋಗಿ ಎಕ್ಸ್ಪ್ಲೋರ್ ಮಾಡಂಗಿಲ್ಲ. ಇಟ್ಸ್ ಟೋಟಲಿ ಪ್ರೊಹಿಬಿಟೆಡ್ ಟು ಕಿಲ್ ಡ್ಯೂರಿಂಗ್. ಈ ಡಿಸ್ಟಿಂಕ್ಷನ್ ಮಾಡಬೇಕು. ನೀವು ನೋಡಿ, ಈಗ ಈ ಕ್ಯಾಮೆಲ್ ಅಲ್ಲಿ ತಕೊಂಡು ಆರ್ಮ್ಸ್ ಅಂಡ್ ಅಮ್ಯುನಿಷನ್ಸ್ ಅನ್ನ ಯೂಸ್ ಮಾಡ್ತೀರಾ. ಈಗ ಕ್ಯಾಮೆಲ್ ಕಾಂಬಟೆಂಟ್ ಅಥವಾ ಈತ ಕಾಂಬಟೆಂಟ್ ಅಂತ ಕಷ್ಟ ಆಗುತ್ತೆ, ಡಿಸ್ಟಿಂಕ್ಷನ್ ಮಾಡಕ್ ಆಗೋದಿಲ್ಲ. ಯಾರು ಇದರಲ್ಲಿ ಇನ್ವಾಲ್ವ್ ಆಗಿದ್ದಾರೆ, ವೆದರ್ ಕ್ಯಾಮಲ್ಸ್ ಆರ್ ಇನ್ವಾಲ್ವ್ಡ್ ಡ್ಯೂರಿಂಗ್ ವಾರ್ ಸಿಚುಯೇಷನ್ ಆರ್ ನಾಟ್ ಅಂತ. Distinction must be made available when you are actually running with the law of war as such. Look at the child soldiers. In these days, the states are actually giving more importance to these child soldiers. It is totally prohibited as far as Rome Statute 1998 as such. It has to be taken into note of at the international level as such. These are the issues and challenges in connection to child soldiers. See, look at all these. Okay. So with these few aspects, of course, no matter, much has been discussed on law of war. It takes time to understand what is law of war and humanitarian law as such. You have to understand. However, you might have got some rights. What are rights? Obviously, rights have come through on the basis of value of utility. This is what your JS Mill has emphasized. Even in otherwise manner, Karl Werner Savigny of Germany and Henry Maine of United Kingdom, they say that your rights have come through on the basis of the cultural variables. So that has to be looked upon. And moreover, if rather I would say, this is what we are Krishna are in many cases expressed before Honorable Supreme Court of India by saying that access to justice is one among human rights that has to be looked upon, and you have to give voice to the voiceless. That's very, very important. We need a code comprehensively relief oriented and humanistically comprehensive, reluctantly positive, and forensically streamlined for mass delivery of justice to the iceless, then speechless, rightless, and remediless people. So that's why at the end of this session, I must share with you, instead of just relying on punishment, why don't we want to have a cultural change in the society as such. We need to have social defenses and the cultural changes through which we can understand humanity as such. Humanity has to be looked upon, and you have to give more importance to equality. I mean to say, you cannot be a stronger by exploiting others. All are equally footing. Nobody is actually superior or inferior. So that has to be looked upon when it comes to the knowledge of the law in which we have been actually running here and there to understand the problems of the human being all over the world, as not only in a national level but also at the international level as such. Thanks to United Nations organization for having gone through as many as a specific legislations to understand the problems of a human being here and there. So with this, I extend my heartfelt gratitude to all of you for giving me this opportunity to share few thoughts on few aspects like bioterrorism and the law for war as such. If you have got some questions, I'm happy to share few responses. Do you have some questions?
Sir, here is a question, sir. Sir, ಈಗ ನಮಗೆ ಈಗ ಇಂಟರ್ನ್ಯಾಷನಲ್ ಕನ್ವೆನ್ಷನ್, ಕೋವೆನೆಂಟು ಅಥವಾ ಟ್ರೀಟಿ ಇತರೆ ಎಲ್ಲವೂ ಕೂಡ ಇತರೆ ಅಂತಾರಾಷ್ಟ್ರೀಯ ಮಟ್ಟದಲ್ಲಿ ಹಲವಾರು ರಾಷ್ಟ್ರಗಳು ಅದಕ್ಕೆ ಸಿಗ್ನೇಟರಿ ಆಗಿರುವಂಥದ್ದು. ಫಾರ್ ಎಕ್ಸಾಂಪಲ್, ಈಗ ಚೈನಾ ಮತ್ತು ಪಾಕಿಸ್ತಾನ ವಿಚಾರವನ್ನು ತೆಗೆದುಕೊಂಡು ನೋಡಿದಾಗ ಚೈನಾ ವರ್ಸಸ್ ಫಿಲಿಪೈನ್ಸ್ ಕೇಸ್ನಲ್ಲಿ ಇಂಟರ್ನ್ಯಾಷನಲ್ ಕೋರ್ಟ್ ಆಫ್ ಜಸ್ಟಿಸ್ ಫಿಲಿಪೈನ್ಸ್ ಪರವಾಗಿನೇ ಒಂದು ಜಡ್ಜ್ಮೆಂಟ್ ಅನ್ನ ಕೊಡ್ತು. ಆದ್ರೆ ಚೈನಾ ಆ ಜಡ್ಜ್ಮೆಂಟ್ ಅನ್ನೇ ಧಿಕ್ಕರಿಸಿ ನಾನು ಅದನ್ನ ಬಾಧ್ಯನಲ್ಲ, ಅದಕ್ಕೆ ನಾನು ರೆಸ್ಪಾನ್ಸಿಬಲ್ ಅಲ್ಲ, ಅಕೌಂಟಬಲ್ ಅಲ್ಲ ಅಂತ ಈಗಲೂ ಕೂಡ ವಾದ ಮಾಡ್ತಾ ಇದೆ. ಹಾಗಾದ್ರೆ ಕನ್ವೆನ್ಷನ್ ಅಥವಾ ಕೋವೆನೆಂಟ್ ಇಂಥವೆಲ್ಲ ಯಾವ ರೀತಿಲಿ ಅದು ಬೈಂಡಿಂಗ್ ಆಗತ್ತೆ ಅನ್ನೋದು ಒಂದು. ಮತ್ತೆ ಪಾಕಿಸ್ತಾನ ವರ್ಸಸ್ ಇದು ಕುಲಭೂಷಣ್ ಜಾಧವ್ ಎಸ್ಪಿಯೋನೇಜ್ ಕೇಸ್ನಲ್ಲಿ ಹೌದು, ಇಂಟರ್ನ್ಯಾಷನಲ್ ಕನ್ವೆನ್ಷನ್ ಇದ್ರೂ ಕೂಡ ನಮಗೆ ಕಾನ್ಸುಲರ್ ಆಕ್ಸೆಸ್ ಅನ್ನ ಕೊಡುವುದಕ್ಕೆ ಸಾಕಷ್ಟು ತೊಂದರೆಯನ್ನ ಕೊಡ್ತು ಪಾಕಿಸ್ತಾನ. ಜಡ್ಜ್ಮೆಂಟ್ ಭಾರತದ ಪರವಾಗಿ ಆಗಿದ್ರು ಕೂಡ. ಹಾಗಾದ್ರೆ ಇದರಿಂದ ಅದು ಎಷ್ಟು ಮಟ್ಟಿಗೆ ಬೈಂಡಿಂಗ್ ಮಾಡಬಹುದು ಮತ್ತೆ ಅಕೌಂಟಬಲ್ ಆಗಿ ಆ ರಾಷ್ಟ್ರಗಳನ್ನ ನಾವು ಮಾಡಬಹುದು, ಅಂತಾರಾಷ್ಟ್ರೀಯ ನ್ಯಾಯಾಲಯದಲ್ಲಿ ಆಗಿರ್ಬೋದು ಅಥವಾ ಕನ್ವೆನ್ಷನ್ ಆಗಿರ್ಬೋದು?
ಸೊ ಒಂದು ಹೇಳಲಿಕ್ಕೆ ಇಷ್ಟಪಡ್ತೀನಿ. ನಿಮ್ದು ಫಸ್ಟ್ನೇ ಪ್ರಶ್ನೆ ಏನಂದ್ರೆ, ಈ ಆರ್ಟಿಕಲ್ 36 ಪ್ಯಾರಾಗ್ರಾಫ್ 1 ಆಫ್ ಇದು ICJ ಚಾರ್ಟರ್ 1946 ಅಲ್ಲಿ ಕ್ಲಿಯರ್ ಆಗಿ ಹೇಳಿದೆ, ಯಾವುದೇ ಒಂದು ಇಶ್ಯೂ ಅನ್ನ ಅಂತಾರಾಷ್ಟ್ರೀಯ ನ್ಯಾಯಾಲಯದಲ್ಲಿ ತಗೊಂಡು ಹೋಗಬೇಕಾದ್ರೆ ಒಂದು ಅಗ್ರಿಮೆಂಟ್ ಆಗ್ಬೇಕು. ಅದು ಏನು, ಡಿಪ್ಲೊಮ್ಯಾಟಿಕ್ ಅಗ್ರಿಮೆಂಟ್. ಅದು ಆ ಅಗ್ರಿಮೆಂಟ್ ಮುಖಾಂತರ ನೀವು ಕೇಸನ್ನ ಫೈಲ್ ಮಾಡ್ತೀರಿ. ಸೊ ಒಂದ್ ಸಾರಿ ನೀವು ಅಗ್ರಿಮೆಂಟ್ ಮುಖಾಂತರ ಕೇಸ್ ಫೈಲ್ ಆದ್ಮೇಲೆ ಎಲ್ಲ ಪ್ರಿಲಿಮಿನರಿ ಹಿಯರಿಂಗ್ ಎಲ್ಲ ಆಗುತ್ತೆ, ಜಜ್ಮೆಂಟ್ ಎಲ್ಲ ಬರುತ್ತೆ. ಜಜ್ಮೆಂಟ್ ಅನ್ನ ಫಾಲೋ ಮಾಡ್ಬೇಕಾದ್ರೆ, ಅಕ್ಸೆಪ್ಟ್ ಮಾಡ್ಕೋಬೇಕಾದ್ರೆ ಆ ಪಾರ್ಟಿಗಳದ್ದು ಜವಾಬ್ದಾರಿ. ದಟ್ ಇಸ್ ಮೋಸ್ಟ್ ಇಂಪಾರ್ಟೆಂಟ್. ಆ ಸಂದರ್ಭದಲ್ಲಿ ಏನಾದ್ರು ಫೇಲ್ಯೂರ್ ಆದ್ರೆ ನೀವು ಯಾವ್ದೋ ಆಕ್ಷನ್ ಅನ್ನ ತಗೋಬಹುದು ಅಂತಾರಾಷ್ಟ್ರೀಯ ಮಟ್ಟದಲ್ಲಿ. ಇಲ್ಲಿ ಸೆಕ್ಯೂರಿಟಿ ಕೌನ್ಸಿಲ್ಸ್ ಇದರಲ್ಲಿ ಅಥವಾ ಜನರಲ್ ಅಸೆಂಬ್ಲಿ ಅಲ್ಲಿ ಏನಾದ್ರು ಡಿಸ್ಕಷನ್ ಟೈಮಲ್ಲಿ ಅಂಥದ್ರಲ್ಲಿ ತಗೋಬಹುದು. ಅದಕ್ಕೆ ಅವಕಾಶ ಇದೆ. ಇದೊಂದು. ಆಮೇಲೆ ಇನ್ನೊಂದು, ನಾನು ಆಗ್ಲೇ ಹೇಳಿದ್ದೀನಿ, ಯಾವುದೇ ಒಂದು ಅಗ್ರಿಮೆಂಟ್ ಅನ್ನ ಫಾಲೋ ಮಾಡ್ಬೇಕಾದ್ರೆ ಪ್ಯಾಕ್ಟಾ ಅಂಡ್ ಸರ್ವಾಂಡ ಅಂತ ಇದೆ. ಪ್ಯಾಕ್ಟ್ ಮಸ್ಟ್ ಬಿ ರೆಸ್ಪೆಕ್ಟೆಡ್. ಈಗ ಒಂದು ಅಗ್ರಿಮೆಂಟ್ ಮಾಡ್ಕೊಳ್ತೀರಿ, ಯಾವುದೋ ಒಂದು ಜಮೀನಿಗೆ ಸಂಬಂಧಪಟ್ಟಂತೆ ಅಗ್ರಿಮೆಂಟ್ ಮಾಡ್ಕೊಳ್ತೀರಿ ಅಥವಾ ಕಾಂಟ್ರಾಕ್ಟ್ ಮಾಡ್ಕೊಳ್ತೀರಿ ಸಪ್ಲೈ ಮಾಡ್ಲಿಕ್ಕೆ ಯಾವ್ದಾರ ಒಂದು ಥಿಂಗ್ಸ್ ಅನ್ನ. ನೀವು ಅಗ್ರಿಮೆಂಟ್ ಅನ್ನ ಫಾಲೋ ಮಾಡ್ಲಿಲ್ಲ ಅಂತಂದ್ರೆ ಅಗ್ರೀಡ್ ಪರ್ಸನ್ ವಿಲ್ ಗೋ ಟು ಕೋರ್ಟ್. ಯಾಕೆಂತಂದ್ರೆ ಅಲ್ಲಿ ಬ್ರೀಚ್ ಆಫ್ ಅಗ್ರಿಮೆಂಟ್ ಅಥವಾ ಬ್ರೀಚ್ ಆಫ್ ಕಾಂಟ್ರಾಕ್ಟ್ ಆದಾಗ ಹೋಗೋದು ಅವಕಾಶ. ಇದು ಲೋಕಲ್ ಲೆವೆಲ್ಗೆ ಮಾತ್ರ ಸಂಬಂಧಪಟ್ಟಿದೆ, ಈ ನ್ಯಾಷನಲ್ ಲೆವೆಲ್. ಇಲ್ಲಿ ಅಂತಾರಾಷ್ಟ್ರೀಯ ಮಟ್ಟದಲ್ಲಿ ಈ ಅಂಶ ಇದೆಯಲ್ಲ, ಇದು ಭಾರಿ ಡಿಬೇಟಬಲ್ ಇದೆ. ಯಾಕೆಂತಂದ್ರೆ ಯಾವುದೇ ರಾಷ್ಟ್ರಗಳನ್ನ ನೀವು ಬೆಂಡ್ ಮಾಡಕ್ ಆಗೋದಿಲ್ಲ, ಕಷ್ಟ ಆಗ್ತೈತಿ ಕೆಲವಂತ ಸಂದರ್ಭದಲ್ಲಿ. ಸೊ ಅಂತ ಸಂದರ್ಭದಲ್ಲಿ ಏನಾಗ್ತೈತಿ ಅಂತಂದ್ರೆ, ಈಗ ನಾನು ಏನ್ ಹೇಳ್ತೀನಿ ಅಂತಂದ್ರೆ, ಈ ಯುನೈಟೆಡ್ ನೇಷನ್ಸ್ ಆರ್ಗನೈಸೇಷನ್ಗೆ ಸಾಕಷ್ಟು ಪವರ್ಸ್ ಅನ್ನ ಕೊಟ್ಟಿದೀವಿ, ಇಲ್ಲ ಅಂತ ಹೇಳಲ್ಲ. ಆದ್ರೆ ಮಿಲಿಟರಿ ಫೋರ್ಸ್ ಅನ್ನ ಯಾಕೆ ಕೊಡ್ತಾ ಇಲ್ಲ? ನಂಬರ್ 1, ಮಿಲಿಟರಿ ಫೋರ್ಸ್ ಅನ್ನ ನಮ್ಗೆ ಅವ್ರಿಗೆ ಕೊಟ್ರೆ ತುಂಬಾ ಹೆಲ್ಪ್ ಆಗ್ತೈತಿ. ಆ ನಿಟ್ಟಿನಲ್ಲಿ ಒಂದು ಮಿನಿಮಮ್ ಅಂದ್ರೆ ನಿಮಗೆ ಗ್ರಾಸ್ ನ್ಯಾಷನಲ್ ಇನ್ಕಮ್ ಏನಾದ್ರೂ ಇದ್ರೆ ಎಲ್ಲಾ ರಾಷ್ಟ್ರಗಳು 193-94 ಕಂಟ್ರೀಸ್ ಏನಿದೆ ಇವರಲ್ಲ, ಗ್ರಾಸ್ ನ್ಯಾಷನಲ್ ಇನ್ಕಮ್ ಅನ್ನ ನೀವು ಯುನೈಟೆಡ್ ನೇಷನ್ಸ್ ಆರ್ಗನೈಸೇಷನ್ ಕೊಡಿ, ಅಲ್ಲಿ ಒಂದು ಟಾಸ್ಕ್ ಫೋರ್ಸ್ ಅನ್ನ ಮಾಡ್ತಾರೆ. ಟಾಸ್ಕ್ ಫೋರ್ಸ್ ಅನ್ನ ಮಾಡಿದ್ರೆ ಅಟ್ಲೀಸ್ಟ್ ಮಿಲಿಟರಿ ಎನ್ಫೋರ್ಸ್ಮೆಂಟ್ ಇದಾಗುತ್ತೆ. ಏನಾಗ್ತೈತಿ ಅಂತಂದ್ರೆ ಈಗ ಬರೀ ಜಜ್ಮೆಂಟ್ ಬಂದಿರುತ್ತೆ, ಅವರಿಗೆ ಹೇಳ್ತಾರೆ. ಈಗ ಉದಾಹರಣೆಗೆ ಇದೊಂದೇ ಕೇಸ್ ಅಲ್ಲ, ಈಗ ಯಾವ್ದು ಕರ್ಫ್ಯೂ ಚಾನಲ್ಸ್ ಕೇಸಲ್ಲಿ ಸುಮಾರು 20 ವರ್ಷ ಆಯ್ತು ಕಾಂಪನ್ಸೇಷನ್ ವಾಪಸ್ ಕೊಡಕ್ಕೆ. ಸೊ ಇವೆಲ್ಲ ಇದಾವೆ, ಇಲ್ಲ ಅಂತ ಹೇಳಲ್ಲ. ಇಂಪೋಸ್ ಮಾಡ್ಬೇಕಾದ್ರೆ ಈಗ ನಮ್ಗೆ ಏನಾಗ್ತೈತಿ ಅಂದ್ರೆ ಇಂಡಿವಿಜುವಲ್ಸ್ ಒಬ್ಬ ತಪ್ಪು ಮಾಡಿದ ಅಂದ್ರೆ ಬೇಕಾದ್ರೆ ಅವತ್ತು ರೇಪ್ ಮರ್ಡರ್ ಮಾಡಿದ ಅಂದ್ರೆ ಪನಿಷ್ಮೆಂಟ್ ಮಾಡ್ಬೋದು. ಆದ್ರೆ ಅಂತಾರಾಷ್ಟ್ರೀಯ ಮಟ್ಟದಲ್ಲಿ ನೀವು ಯಾವುದೇ ರೀತಿಯಲ್ಲಿ ಪನಿಷ್ಮೆಂಟ್ ಇಲ್ಲ. ಯು ಕ್ಯಾನ್ ಹ್ಯಾವ್ ಕಾಂಪನ್ಸೇಷನ್, ರಿಪರೇಷನ್ ಅಥವಾ ಕಾಂಪನ್ಸೇಷನ್ ಕೇಳ್ಬೋದು ಅಷ್ಟೇ. ಅದಕ್ಕೋಸ್ಕರ ಈಗ ನಾನು ನಿಮ್ಮ ಕ್ವಶನ್ ಬಿಟ್ಟು ಹೇಳೋದಂದ್ರೆ ರೋಮ್ ಸ್ಟ್ಯಾಚ್ಯೂಟ್ 1998 ಅಲ್ಲಿ ಇಂಡಿವಿಜುವಲ್ ಕ್ರಿಮಿನಲ್ ರೆಸ್ಪಾನ್ಸಿಬಿಲಿಟಿ ಅಂತ ಯಾಕೆ ಮಾಡಿದ ಅಂತಂದ್ರೆ ಇಂಥವ್ರನ್ನೆಲ್ಲ ಒಳಗ್ ಹಾಕ್ಲಿಕ್ಕೆ. ಯಾಕೆಂತಂದ್ರೆ ಇವರೆಲ್ಲ ಈ ದೇಶದ ಹೆಸರು ಹೇಳ್ಕೊಂಡು ತಮ್ಮ ವ್ಯಕ್ತಿತ್ವವನ್ನು ಬೆಳೆಸ್ಕೊಂಡ್ರೆ ಅಂತಾರಾಷ್ಟ್ರೀಯ ಮಟ್ಟದಲ್ಲಿ ಜನರಿಗೆ ಟಾರ್ಗೆಟ್ ಮಾಡ್ತಾರೆ. ಸೊ ಇದಕ್ಕೋಸ್ಕರನೇ ಅಂತಾರಾಷ್ಟ್ರೀಯ ಮಟ್ಟದಲ್ಲಿ ICC ಯಾಕೆ ಬಂತು ಅಂತಂದ್ರೆ 2002 ಬಂತದು. 2002 ಬಂದ್ರು ಈಗ ಕ್ರೈಮ್ಸ್ ಅಗೇನ್ಸ್ಟ್ ಹ್ಯುಮ್ಯಾನಿಟಿ, ವಾರ್ ಕ್ರೈಮ್ಸ್, ಜಿನೋಸೈಡ್, ಆಮೇಲೆ ಪೀಸಿಗೆ ಸಂಬಂಧಪಟ್ಟಂತೆ ಎಲ್ಲಾರು ವೈಲೇಷನ್